besides this is obviously going to be, you want to know what really happened, you need to watch this. This is the only place you're going to get this type of interview or
I don't really know what this is, but I didn't do it. I'm innocent, Judge. I'm not guilty. I'm innocent.
We, the jury, being duly impaneled and sworn, find the defendant Matthew L. Moore not guilty of murder as he stands charged in count 1 of the indictment.
Elvis has left the building. It's done. People, it's over. Elvis has left the building. It's done. Over.
Press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. It would help if I put myself on the screen, wouldn't it? Good morning, good afternoon, good evening to you all. Hope you're all well there. How are we doing, Christine? Good morning, my darling. How are you? Gitmo, hello to you. Hope you're well. Gigi, howdy to you. How are you? Tertia, hello. Hope you're well. I'll be in and out. That's fine. Go. I hope you have a good doctor's checkup there, Tertia. I hope you have a good one, my darling. John, good morning to you, sir. How are you? Out there in Boston? Yeah. I figured out this morning Boston is 3,100 miles from, Canton is 3,100 miles from where I live. How do I know that? Because Larry Curran informed me this morning. I was like, Dylan, how many miles is it from Canton to you? So I had to go on Google and do that. So we're just over 3,105 miles between us, I believe, there. So hello to you. Good morning to you, John, over there. Amy, good morning, my darling. Hope you're well. Nice to see you back on a more of a consistent basis, my darling. Lovely to see you. Patty Murphy, as always, good morning to you, my darling. Hope you are well as well. Zach, that was Zach, not Solomon, but Zach. Yeah, close enough though. Brothers in arms. First time I'm seeing this intro. Oh, I mix it up. I just play whatever I feel like in the mornings. Here he is, celebrity. Hello, Mr. Celebrity number 1, Dana Leonard. Hello, sir. How are you? Hope you are well. Give our love to Tracy as well. Hope you're both doing well there over in Boston. There you go. You love that, Dana. Good morning to you, Disney Queen Carol. How are you doing, my darling? Hope you're well. Figure how to subscribe. You're subscribed. you're subscribed, because if you hang on, let me just check. Oh no, hang on. I didn't put a subscribers mode today, so you figure out. You know what to do, Amy. You were talking yesterday, so and you subscribed, so it's fine. Gigi, hello, my darling. I did see you earlier on. Hello, how are you? Yeah, Trucker. Good morning. How are you doing today? I'm very well, thank you. Beat the gym already today. Yeesh. But made me more tired. But I'm doing all right. Oh, don't you say that. I'm yawning. And I'm doing all right. Yeah, Trucker. How are you, sir? Madam. Sorry, madam. How are you doing? Elise, hello, my darling. How are you? Nice to see you this morning. Right, we got a good day. Now, I think Dana, you might know this. I believe. No, hang on. Where's it gone? So, actually, it doesn't matter. So, my plan is today. Plan of attack. Hello, Charity. Hello, Mama darling. How are you? Is there you go. No worries. Thank you for asking as well, my darling. Is the Sarah Boone hearing from yesterday? I got that. Video from yesterday. So plan is to play that today, this morning. Then from about 9 o'clock. Then hopefully Alexi Traviso will be played at 11. So play that at 11. And then what we'll do then, yeah, there's a few things. Hello, Sharon McDonald. Hello, Sharon. Nice to see you, my darling. Good afternoon, Dylan. Just popping in to wish you well in your live stream, and peeps, don't forget to touch DNA on the like. But thank you, Sharon. Thank you, my darling. Thank you so much for popping in, as always. Thank you, my darling. It's not subscribe I need, it's become a member. Send you money I need. I don't know how to do it. I think it depends where you are. If you're on your phone, I'm not sure. If you're on your laptop or PC, I think it's underneath the chat box. I think that's where I think it is. Otherwise, Sarah P will be here in a bit, or Erin Hack. They know more than me, Amy. I'm a little bit clueless. What is Alexi case? Alexi case is a 19-year-old in New Mexico. You might have heard of her. She was in hospital and she's pregnant. No one knew she's pregnant. I'll take these off. I don't need to wear them right now. She's pregnant in hospital and she gave birth to a baby which no one knew about, and she dumped the baby in a trash can in the toilet. I don't know the ins and outs of it. I don't want to know the ins and outs of it because I want to go to the trial as blind as possible. But I think it's going to be interesting. So yeah, that's the gist of it, Trucker. But the pre-trial hearing is today, so we'll know a lot more today. Debbie Davis, hello. If there's an E between the I and the S, it'd be perfect, Davis. Davies. That's Davies. Davis. That's who I am. Debbie Davies. How are you? Good morning from Northeast Ohio. OH. IO. OH. IO. There's a lot of Michigan people here, Debbie, so careful. I'm joking. Hope you're well, my darling. Thanks for joining us. Hang on, let me check one thing. Bum, ba-da, ba-ba-da, bum, ba. Right, there's that. Right, are you on iPhone, Amy? Oh, Shari might know how to do it. Hey, Zach, how you doing, fella? How you doing, mate? Hi, Dylan and everyone in El Chatty chat. Hit the like button, please. Yes, please, bloody like it. Oh, it's not too bad. It's not too bad. I'm on a phone. I'll have my son look at. Yeah, it's something you have to go through a browser or something. I believe. I'm not 100% sure, but we'll figure it out. Good morning to you, Kim, my darling. Hope you're well. Obviously, this is Kim, not Kimmy. Hey. I said, yeah. I want to know more about it. Though. Good morning. That's a sad. Yes, it is from New Mexico. My father's family originally in Wales and the name was Davis. There you go, with the proper E in it. That's got a proper E in it, Debbie. Davis. instead of Davies, but it's fine. You're close enough. Are you watching via the YouTube app? Good questions. Morning, Nancy. Long time no see, it feels like. How are you doing, my darling? Hope you're well. Good morning to you, Crystal. A lot of people asking how you were yesterday, Crystal. I know you're busy working, so I didn't want to disturb you. I know people are asking after your brother as well. It was lovely to see everyone concerned about you and your brother. No Christmas too early. Evil Olive. Oh, Evil Olive. There's always one. Come on, Olive. Skip the evil part. Just be Olive. Only one song. Only one song. That's it. It's quite catchy. Press the like, press the like, press the like, please, Olive. Press the like and subscribe. It would mean the world to me, Olive, if you liked and subscribed. See, bit of a intro there for you, Olive. What are you covering this week? So today is the day when we become one. Today we're doing Sarah Boone. We are doing Alexi Traviso. We are doing. I got the. Thanks to Carol, I have now got the impact statement with the statements from Chad Dowerman's wife and daughter. So we'll play that. And also, we're going to play the finale of the Judge Boyd trial, I think. They've had now closing arguments, and they started deliberating yesterday. So we could play that today. We can play the final day and the closing today, this afternoon, and then maybe there'll be a verdict today. I don't know, but we'll see. So if there is, we'll play it. If not, so we'll see. That's the plan for today. Tomorrow, I believe we're going to do a 3-day trial in one. Thursday, we'll see what Thursday brings. Friday, obviously, is Karen Reid. So we'll see what happens. Hit it, baby, one more time. My loneliness is killing me, and I still flooded in Sarasota. Oh no. Hey Terry, by the way. Oh my god, Terry. Oh, so sorry. Good morning, Crystal. I'm working today, but I'll be in and out of the chat. That's all good. Glad it didn't come in your house. The weather's awful for you in Florida. TV through. Oh, you have that, yeah. You have to go to the app, the browser, I think, Amy. Thanks, Shari. Good morning, yeah. There you go. I'll leave it to you, Shari. Oops. Was there a verdict? Oh, just talk about that. I'm not sure. There might be been late last night. There wasn't up until a certain point yesterday. But then I'll be honest with you, I didn't look right at the end of the day. So I'm not sure. But don't go looking for it because I'll be playing it today, I think. And then we should, if there's a verdict, we'll play that as well. So closings are done. Defense arrested. Defense, I believe, only had one witness. So we're good to go. Orlando municipal buildings may still be closed due to flood. Wow, it's that bad, yeah? Yes, give me a minute. Do they have any trials in the UK that get recorded? Do you have any comparisons to other countries' trials? They do some civil trials, but not really. There's no. I think there's been like one, but it wasn't. It was turned into a documentary rather than actually seen it gavel to gavel. And they've only just started last year now showing verdicts. Sorry, not verdicts, sentencing. But then you could only see the judge. So, yeah. No, to answer your question, no, they don't. They don't do what we're set out to do. Hey, Crystal. So there you go. So that's a brief synopsis of today. Thursday morning. I'm looking forward to your show. I'm going to listen while waiting at the oncologist office. Oh, well, good luck, Patty. I know she's going to say you're 1.5 year cancer free, but I'm still stressed. Oh, well, T's and P's way. Our thoughts and prayers will be with you, Patty, on Thursday morning. I hope it goes well. I hope everything goes well. I know positive thoughts. I love that. You'll be fine, my darling. But yeah, big day Thursday. Let's go. Smash it. Smash it, Patty. We're with you. Let's go Thursday. Went to Hobby Lobby. What's Hobby Lobby? Yesterday, and they already had some Christmas stuff out, and I was humming like unsubscribe. There you go, Carol. That's the way to do it. I have it open in Safari, but I still don't get see become a member. I feel like this should be much easier. There should be Safari. There should be a thing at the bottom by the chat that says, or somewhere. I don't. Who am I to talk? Who am I to talk? Shari says I'll be in and out as well today. Delan, they're calling. Right, hang on. Let me read this properly. I've been in and out as well today. Delan, they're calling or 10 inches in my hood. Good chance my house will be surrounded with water. So your house could be 10 inches in water. Wow. Well, bloody hell, Shari. I hope it goes okay today. Jeepers, 10 inches. I didn't realize there's a lot of you suffering out there. I didn't realize there were so many of you suffering. So thoughts with you all. Jeepers. Every one of you in Florida. Jeepers. I didn't know it was that bad. Hope it's, jeepers. Craft and Decor. Oh, okay. I've never heard of Hobby Lobby before. Hobby Lobby. Never heard of it before. Lisa Reed, my darling. Thank you for the message last night as well. Good afternoon, Dylan. Good morning, everyone. There you go, Lisa. As always, big part of the chat. You know that. Thank you, my darling, for your message. Loved it. Reading this morning. First thing I did this morning, read your message. Loved it, Lisa. Thank you, my darling. Now, Lisa, I won't lie to you. There might be competition here, right? Hang on. Where's it gone? Where's it gone? No, there. We got Debbie here from Northeast Ohio, so we got a bit of OH going on here as well. OH with a Michigan clan. I'm sure you'll all behave. It's fine. Morning, Lisa. Rain all day here in Michigan. My yard can't take any more rain. No, rain spoiling it all for you all. I'm a loop of Safari asking me to verify by opening. Oh yeah, I don't know. Hey, morning, Sheila. Morning, Quizzical Girl. Hey, how we doing? Good day, mate. Good day, mate. There you go. She got the message. I-O. O-H. I-O. How we doing, Quizzical Girl? Hope you're well, my darling. There you go. There. Thank you, Lisa. There were unfortunately casualties in Florida. Stay safe. Stay safe, everybody. It's raining here in Florida, and South Carolina is getting flooded. The storm is crazy for a cat. Oh, no, category 1. Jeepers. I didn't know it was that bad. 10 inches of rain equates to 15 feet of water in my backyard. I won't be able to leave my house. Jeepers, Shari. Bloody hell. I'll let you do it on the web. I ran into that with my iPad. I deleted the app, did it through Safari, and then reloaded the app. There you go. Go on, Carol. Good day, mate. I'm well, thanks. Quiz Google, put another shrimp on the barbie. Don't put prawns on it, put a shrimp on it. Right. So you've all got the memo now, yeah? We're gonna go. There's a few other hearings today as well, which I might play, but we don't know what's gonna happen. Good morning, Robin. Rocky. What's the song? Rocky, Robin. Rocky be good. Rocky, Robin. Rocky, Robin. Rocky, Robin. Ooh, Robbie be good. Robbie be good. Batman and Robin. I don't know. I'm making stuff up now. I don't know what that means. Morning, Robin. Good morning to you, Bev. How we doing? Bev's crying. Bev's always crying. How we doing, my darling? Oops. Thank you, Carol. I'll have my son do it on his computer. Oh yeah, do it on a computer. Much easier. Much easier. Rockin' Robin. Get those snags. Sass, how we do it, Sass Mars? Snags. Is that snacks? What snags? What snags? Put the snags on the Barbie. Put the snags on the Barbie. Right, let's have a look. I'm going to start at 9 o'clock. Okay. Sausages. Oh, okay. Yeah, easier. Morning. Hello to you, Robin G. Sausages, fine. Okay. Sorry, I got to get my water. I drank this, my first one of the day, proper one. I feel a bit dehydrated. Roadkill, maybe. I don't know. I'm just making a song up. I don't know where it's come from. So, first of all, I'll start in 5 minutes. But we have the famous Boone. Fuck. Don't start yet. Don't start yet. Thank you very much. I need some more people at 9 o'clock. Right, let me just get this ready. I'll put it on screen. Then I'm going to have to keep an eye out for Alexi Traviso as well. To see if she's starting at 9 o'clock. Hey, Josie, my beautiful Josie. How we doing, Josie? Everyone say hello to Josie. Hot Mama, as you all were calling her the other day. How we doing, Josie? Hope you're well, my darling. I'm sculling coffee onto the second pint. I got coffee, if you can see it, in my El Jefe and El Chappy free Karen Reed mug. I got my coffee in this one. So I'm sculling it as well. Hydrate, dehydrate. Hydrate, dehydrate. So look at the love for Josie. I love it. Good morning, Josie. Morning, Josie. To become a member, I just searched and it says to go to the channel main page and there's a join button. There you go, Yaya Trucker. Lou's in the house. Not Lou Barber, but Lou Hillier Psych. Hi, Dylan and chat. Hi, Josie81. There you go. How are we doing, Lou? Hope you're well. I love when Lou's in here. How are you? The IQ seems to always go up when Lou's around. How are we doing, my darling? Hope you're well. Hills of Western Mass, morning to you. How are we doing? Hope you're well. There you go, John. Thank you so much to John for the gifted membership. Who was a lucky person to get it? Debbie Davis. Debbie Davis got gifted the membership. So there you go, Debbie. Debbie. There she is. So an Ohio one has got it. Thank you, John. Thank you so much for gifting that to Debbie. That's very generous of you, my friend. Thank you so much. Morning, Lou. Hey, Lou Barber. How's Archie? How we doing? Oh, thank you, Josie. I need to pin that. I always forget to do it. So I always wait for you girls to do it. Thank you, my darling. Lou Barber's here with baby Archie. Hope you're doing well, my darling. Nice to see you. Nice. Sasmas, someone told me to put a little sea salt in water and it keeps electrolytes good. Oh, okay. Well, I put my finger in sea salt water. So hang on, before I do this, right? So I've done something to my finger. I don't know what I've done to it, right? But when I Googled it, it said something. So I think I've got an infection. On my finger, somewhere there. You can see it. It's like right by the nail there. Starting to turn green. I can only see the doctor 3.5 weeks. So they said it's probably an infection. It's quite normal, they said. There's a name for it. So I put my finger in sea salt water. No, in salt and water to try and keep it clean. They said to do that twice a day. So I don't know. I just thought about that as you mentioned that about Electrolytes. Hey Lou. Hey Lou, I'm glad I crack you up rather than make you cry. Are you and Sean coming Friday's hearing? So, good question, Mr. O. Sean is on holiday. So Sean will not be here in person on Friday on it. So he's away for 2 weeks. So yeah. Now I don't really want to promise that he'll be here, as in because I've told him not to be here, but he might be phoning in pre and post the hearing. But he is with his wife. They are going on their wedding anniversary. So I'm glad that they're going. Obviously, sucks that he's not here, but I'm super glad he's going with his wife. But he still wants a link, as Sean typically does. And I think he might be phoning in. So he won't be here as our normal show, but hopefully he phones in. Now, I'm not going to promise him because, like I said to him, his wife comes first, not the hearing. So he needs to spend time with her. But knowing Sean, he'll probably pop on. So no, he won't be here Friday, but he will maybe be here Friday. I don't know what the fuck I'm saying. He might call in. He might call in. I'm not making any promises though, so don't hold me to it, Mr. O. Don't hold me to it. So go, John. That's lovely. It is lovely. Thank you, John. Help support. There you go. Oh, was that a new one? Did I pin the wrong one? Oh no, that's the right one. Thank you, Josie. Congrats, Debbie. I wish I could become a member. Don't. There's something that you can press to become a member. S. Kelly. Hello. You're awesome. Thank you, S. Kelly. Thank you for being here, my darling. Moi Lou. Hello. Thank you for so much. There you go, Deb. Hello, Lou B. Make sure you have gifted membership turned on. Yes. Arsenal's Kim. Oh yeah, could ask it. No, it's not a blister. It's hang on. Let me show you. Next to it is right. It's this Paranachia. Paranachia. Whatever that is. I don't know what the fuck it is. Paranachia, apparently. Maybe. That's my self-diagnosis anyway. Miss Jessica, hello, my darling. You popped in yesterday. I didn't say hello to you. Hello, my darling. Hope you're well. Good morning, Robin. I'm Dennis Sweeney with Tyson here. I love the serial. No, it's Larry. It's Larry. Larry Curran. Larry might call in on Friday with Tyson. He might call in on Friday with Tyson. So he might be here. No, so yeah, I did for 15 minutes today. They got to cut into it apparently to get the infection out or something. I don't know. We'll get it. Not something like this. No, it's that paronachia or whatever it's called. Good morning to you all. Sasamas. I'll clean it up. Even straight salt under plasto sting like fudge, but speed up healing. There you go. They need to open it, I think, to get the infection out, but it's fine. If you can get batter for your finger, then it will help. It's a solve usually sold in grocery store. Okay. It's not painful. It's only painful when I touch it. Apart from that, it's not painful. There you go. I need to mark that then, Carol, just to hit them all. I don't know what the hell you guys are talking about. Take zinc supplement too, and it'll help heal the wound. It's not even a wound. It's just a thing. I don't even know what it is. 2 o'clock, Mr. O. 2 o'clock. Hello, Jessica. Hello, Logan. Hello, Carter. Hello, family. How are we doing? Was it a hangnail? What's a hangnail? I would like. It's not pink. It's red and it's a bit hot and it's turning green, but it's not painful unless I press it. Yeah, he's taking some time away, but he'll probably come back on the show on Friday as a call in anyway. So we'll see. There you go. Join the Facebook group, people. Good morning, Karen. We believe 11 o'clock. We believe. Thank you, Robin. Die from something that started off as a foot of a big cable. Yeah, no, I know. But like I was to say, I got a doctor's appointment in 3.5 weeks, so I'm keeping it clean. I can't squeeze anything out. It's solid. It's like there's nothing to squeeze out. Hey, Bill, how you doing, fella? That's the one, Carol. That's the one. Paronekia. That's the one. Lady E, hello to you, aka E Sid. How are you doing, Lady E? Green is infection. Yes, a little bit of starting green. I slipped in the rain last night and scrapped up my big toe. Oh no. Nothing squeezed out yet, but we'll see. Hey, Logan. Hey, Sarah P. Hello, hippie chick. Right, let's get started with Sarah Boone. I know. How many there's little pieces of skin that stick up sometimes. Yeah, that's what it was. I pulled it. I pulled it out. It was sticking up, so I pulled it, and then it became like this. So I will Google it, Carol. I will. Morning to you. Ah, there you go. Archie, love it. Yeah, 3.5 weeks. It's UK. We're awful. Hubby's a doctor. You need. There you go. I will Google that in a second. Nurse Nancy says, "Oh, Nurse Nancy. Hello, Nurse Nancy. If you can't squeeze warm soaks. Yeah. So that's what I was doing. My finger was in a cup. I'll do it again later with some salt, warm water, left it in there for 15 minutes. It's not even painful. Do you know what I mean? It's only when I press it, it's painful. So don't pull it, clip it. Yeah, well, it's sticking out. I didn't know what it was, so I just pulled it. Oh, good luck to you, my darling. Good luck, my darling. Okay, I need to look at stuff up. Right, I'll look it up, right, whilst we're watching this. Let's go Sarah Boone on, people. Let's get her on. This is from yesterday, people, what we missed, okay? Welcome to you all. Love you all. Thanks for being so caring. I loves it. So here is Booney. This is from yesterday, so you have not missed anything. Corn Pope, hello, my darling. How are you? Hope you're well. You've not missed anything, people. Here we go. Let's play it. And then I'll keep an eye on Trevizo as well. Right, how the fuck do I do this there?
Case number 2020-CF2603, the state of Florida versus Sarah Boone, state.
Catch Trump out of the state, William Jacob state.
Ms. Boone, raise your right hand to be sworn, please. Please swear to affirm the testimony you should give shall be the truth, the whole truth, and nothing but truth, so help you God.
Yes.
Ma'am, good morning. Can you please state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
I do see that we have a representative from JACS that's appearing virtually. Sir, can I get you appearance for the record as well?
Yes, Your Honor. Christian Lake with the Justice Administrative Commission.
Okay, very good. All right, we've got a couple of things that we're going to be addressing this morning. The first is the motions, Ms. Boone, that you had made reference the last time I saw you. The court has reviewed all of those motions. I've reviewed also JACS's reply, specifically their response to the motion seeking due process costs that was filed on July 30, 2024. State, have you had the opportunity to review all of Ms. Boone's motions?
Yes, Your Honor.
Okay, all right. Ma'am, I want to go through each one of them and hear from the state, from yourself, and from JACS. We're going to start first with y'all can be seated, you don't need to stand, thank you. The defendant's temporary motion for reservation of proposed cost to acquire investigator for defendant's defense and trial dated July 18, 2024, received July 29th. That request seeks to reserve any and all costs proposed to be incurred to acquire investigator. the defendant's temporary motion for reservation of proposed costs to acquire all witnesses for defendant's defense in trial dated July 18th, 24, received July 29th, 2024. The request is to reserve any and all costs proposed to be incurred to acquire all witnesses for trial. And then defendant's temporary motion for depositions to be conducted per FRCP Rule 3.220 by defendant under pro se attorney title and position ordered by the judge in court dated July 18th, 2024 and received July 29th, 2024. I have reviewed all of those motions. All three motions reflect to be determined or TBD with regard to the investigator, witnesses, and deponents. The total amounts are to be determined. How to calculate is unknown. As to the depositions, the date are to be determined and the amount of transcripts are unknown. Mr. Lake, I've reviewed your response. Do you have anything else to add, sir, with regard to those items, investigators, witnesses, or deponents?
Not really, Your Honor. The only thing is if we can provide Ms. Boone a copy of our pro se packet that has information about, including model motions. We would be happy to send her a copy or to send your JA a copy that you could send to give to her. That might help her for purposes of future motions. But as far as these are concerned, I think our response pretty much outlines what our position was to each of those requests.
Okay, thank you, sir. If you would be so kind to send that to Ms. Barrios, we will ensure that Ms. Boone gets a copy of it. State, do you have any position with regard to those three motions that the court just identified?
No, Your Honor.
Okay. All right, ma'am. So previously, Prison Break Investigations was already appointed to be your investigator. The JAC has no objection to authorizing $5,000 in costs for prison break and for $500 for obtaining case-related documents and materials on your behalf. So seeing as there's no objection, even though you were asking for a reservation, I'm going to go ahead and permit that cost to be incurred. With regard to the costs for witnesses and the depositions, you are requesting, as I identified earlier, just to reserve those costs. And as I had said earlier, the motions do not identify who the witnesses are or what the deponents are. So I'm going to deny those motions with prejudice, but that means you can refile them and we can readdress them when you file motions in the future addressing any of those items for ensuring witnesses being subpoenaed or appearing for your defense at trial, or for any persons that you may seek to depose. Because as of right now, I don't know who it is that you were seeking to depose based on your own motions. Do you understand the court's ruling as to those three motions, and do you have any questions, or do you want to add anything?
I would like to add, please.
Sure.
With your delegated due date of July 22nd, for all of my pretrial motions to be submitted, I have yet to receive my discovery, so I was trying to meet that deadline or at least meet it. So I don't know what I'm supposed to ask for or who I'm supposed to ask for. And again, I have yet to receive my discovery, so I don't even know who it is I need. So I understand for those. So you're telling me at a later date, once I have that information, to revise them. I'm
giving you the opportunity to refile. Yes, ma'am.
Thank you.
With regard to the defendant's motion for reservation of proposed costs to With regard to defendant's motion for reservation of proposed costs to acquire expert witnesses for the defendant's defense in trial dated July 18th, 2024 and received July 29th, 2024. Mr. Lake, anything else to add other than what is identified in your response?
No, Your Honor. Again, the issue here is with the exception of the mental health expert that's already been approved, there would need to be much more specific motions for these costs. Ms. Boone needs to include essentially what we included in our response. And again, the model motions that we will be sending to will have that information. Without specific information, neither us nor the court can make an informed decision on whether the requests are appropriate.
Okay. Ma'am, the motion fails to identify any specifics. It has to be determined for your expert witness or witnesses. It does not identify the type of the witnesses. It doesn't identify the amounts, and it's difficult for me to identify the particular showing of need, which is what's required for the appointment of that expert. So again, I'm going to give you the opportunity to refile in the future a motion pertaining to any specific experts identifying the specificity that JACS has requested in their response. So at this point in time, that motion is denied without prejudice, and you'll have the opportunity to refile it. Lastly is the defendant's motion requesting immediate relief to the defendant by appointing effective standby counsel to aid and support in preparation of a criminal case for trial dated July 18, 2024, and received July 29, 2024. The request, ma'am, that you were seeking in that motion is to provide immediate relief to defendant by appointing effective standby counsel to aid and support in preparation of her criminal case for trial. State, do you have any position with regard to Ms. Boone's request for standby counsel?
No, Your Honor, other than what's already been placed on the record in the court's order.
Okay. Mr. Lake, anything over and above what's in your response?
Just briefly, Your Honor, the point we would make, Your Honor, is I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who has decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State 152 Southern 3rd 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State 449 Southern 2nd 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State 45 Southern 3rd 110 at pinpoint 114 through 115. Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se and with legal representation by the Florida Supreme Court in 2009 in Shepard v. State, 17 Southern 3rd 275 at 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied. Do you have any other questions, ma'am, as to the court's rulings this morning?
First off, I did not forfeit my rights. That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity, or if it's just something that is denied, period.
It is denied, period. With regard to an evidentiary hearing, that seems to be in the realm of a Ferretta inquiry where a criminal defendant is seeking to represent themselves. And I would inquire of that person and have an evidentiary hearing as to the rights and remedies that you were forfeiting and the pros and cons of proceeding representing yourself and the benefits of being represented by counsel. Due to the Florida case law that was provided in the 16-page order, no such evidentiary hearing is required.
My understanding was the hearing, the Beretta hearing is in regards to competency as opposed to having an understanding before you take someone's right away.
Beretta pertains to a criminal defendants seeking to represent themselves. Beretta was not applicable to your situation, and that's identified in the case law citations that were provided in the 16-page order.
Yes, I understand. It was the day of that I was explained most of all of this, and as opposed to prior, so I would know what would happen or could happen. So my understanding is one thing, and then the explanation is another. So I'm just confused and feel that I should have had an opportunity prior to all of this to explain myself and to have a better understanding. So now my belief was that the evidence or the Beretta hearing was simply competency. So the evidentiary hearing I thought would be a collaboration of the information of why I wrote my letters in order for you to remove my right to counsel. That, in my opinion, I felt that it was a type of retaliation by the court because you did not understand or attempt to understand any of my letters that I wrote previously, which was for the intervention of the judge and or the court to avoid any of this with me sitting in front of you presently.
Ma'am, as identified in my 16-page order, I listened to every audio hearing. I specifically provided dates and times and words that were specifically said at particular hearings involving yourself and prior counsel. I also made reference in the 16-page order to statements that were made in your letters. I promised you, I've read everything in the court file. I've read every single letter, and I've listened to every single audio. That decision was not made lightly, and it took a lot of time to make that determination and that decision, which explains why it was also a 16-page order. That order stands, it remains. The court's not going to revise its findings or its determination as to your forfeiture, and alternatively a waiver by virtue of the conduct identified in that order.
Okay, I believe, in my opinion, the order is erroneous, and after I reviewed your 16-page order, there are quite a few incorrect entries, and some of them are based on perjury by the attorneys. And by you reading and then also listening to the audio, you did not listen to me in any way, shape, or form in order for me to explain myself better, so you have an exact understanding of the particulars of each letter for each attorney.
I'm not going to revisit my prior decision.
I understand. I'm just trying to make you aware that it's my opinion.
You, and like we talked about last time, ma'am, you're certainly entitled to that opinion.
Thank you.
All right. My judicial assistant has been in contact with the representative from the Orange County Jail, Sergeant Donald Casey, who is on his way in order to facilitate the transfer of the USB drives from Prison Break Investigations. I do see that Mr. Lane is present. So as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for so as soon as he gets here, we'll be able to address that exchange. What we can do while we're waiting for that representative to appear is address some of the things that were identified in the notice of hearing for today, which is kind of a scheduling conference for when we might be setting up certain deadlines. As of right now, the trial is scheduled for October 7th. The trial will be extended from 2 weeks to 3 weeks. So the trial will take place on October 7th, October 14th, and the third week of October 21st. October 21st is not this division's normal trial week. However, the court has obtained coverage for that week so that should this trial proceed into a third week, we will not have to scramble in order to find coverage, and that we'll be able to efficiently proceed with any evidence or testimony on that third week on October 21. Pre-trial was scheduled for September 24th at 1:30. The court typically has its regular trial case managements on that Tuesday. Due to Ms. Boone representing herself and some of the complex issues that may be involved in this case, I'm inclined to change the date of the pretrial so that we might be able to have our own pretrial separate and apart from all the other cases that may be set for that same trial period. My thought would be to move it to, rather than the Tuesday the 24th, to Tuesday the 26th at 9 a.m.
Is that a Thursday?
Yes, sir. That's Thursday.
That's acceptable to the state.
Ms. Boone, that would give you additional opportunity to prepare for trial as well. Are you amenable to changing that date to September 26th at 9 a.m.?
So an additional 2 days?
Correct. You would still have that time to prepare regardless if we had the hearing on September 24 or September 26th. I'm just moving it so that we don't have 50 or 60 other cases and I can focus more attention on your case specifically.
Of course.
Okay, all right. So pretrial will be rescheduled till September 26th at 9 a.m. One of the issues that I wanted to address was deadlines for production of the state's exhibits and the defendant's exhibits. Now, I'm mindful, Ms. Boone, that you have not reviewed some of the documents that may have been provided. I know most recently, Ms. Cashman spent 20 hours with you alone going over questionings and reviewing some of the materials. I don't know the breadth and scope of what was reviewed to you, but some of it may have been reviewed to you based on counsel's representations. State, I want to address with you first, because Ms. Boone hasn't reviewed the discovery yet, as to what your position is with regard to assembling or finalizing an exhibit list or your exhibits for trial.
As far as providing a list of the specific items that the state seeks entry of?
Correct. I do want it before pretrial. So let me just kind of lay the map for what the court's thinking. The court would have the state provide a exhibit list and a witness list by X date. Ms. Boone would have the opportunity to look at that list. We would then have a hearing where all of the exhibits would be shown to and provided to Ms. Boone. They would be provided on a USB thumb drive that could be utilized with a laptop at the jail. And then she could view all those exhibits here in open court. And then she would be afforded the opportunity to make an objections in writing to any exhibits at a later time by a certain date.
I guess one of the concerns would be that if the state identified specific items that we would seek entry of, depending on the course of the trial and the questioning, there may be other items that have already been disclosed in discovery that may necessitate being entered in, would potentially not be part of this original witness exhibit list. Items that were in the discovery, but if that makes sense.
That does make sense.
Yeah.
And I understand what you're saying. And that seems to be more of a fluid situation as to what may happen at trial, right?
Sure. I don't imagine the court's intent would be for the state to just produce the exact witness lists that have already been sent in discovery and just make a notation of every item of evidence. The idea would be to try to pare down.
That's exactly the idea. Yeah. Now, obviously that wouldn't foreclose you if something was produced in discovery and something that would not be relevant or admissible at a certain stage of the trial, but maybe later became relevant or admissible due to something that happened or something that was said, I would not foreclose the state, nor would I foreclose Ms. Boone from attempting to move that piece of evidence into evidence for the jury to consider. But it would be almost like a civil conference where you and opposing counsel would go over what your exhibits are prior to proceeding to trial. And I think that's important to do that so that Ms. Boone has the opportunity to view those in court so that's on the record as to what she's reviewed, and then give her the opportunity to provide any objections, if any, to any of those exhibits. And again, I wouldn't foreclose you if you want to use items A, B, and C, and that's all you intend on using. I don't know what you intend on using. I don't know what evidence you have. If you only want to use and only show A, B, and C, but are saving D, E, and F for later, depending on what happens, I won't foreclose you from readdressing D, E, and F. But it's just an opportunity to address what it is you think you're going to be seeking into evidence at this time.
So essentially,
Go ahead, sir.
So I think we could accommodate that if we could go around September the 1st for that, and then that would give her an opportunity to review that USB and lodge any objections, and then we could potentially address those objections and go from there.
Okay, and that would be September 1 to have the evidence viewing, for lack of a better word, or for the list to be provided?
For the list in the USB.
Yeah, we're going to make this work for an October 7th trial date, Judge. I think September 1st is probably about the right time frame to have this in-court hearing to begin lodging those objections if she has any. My next question is, are you expecting the physical evidence to be brought here into court by a CSI so that she can potentially open it? Or are we just talking about digital evidence and giving her a list of the physical items?
If there's physical evidence that's sought, I want her to have the opportunity to review it.
And we should be looking at the top of the month for September so that we can get this done.
Okay, all right. Ma'am, do you understand that what it is that I'm discussing right now, so that you have the opportunity to review the evidence that the state may be seeking into evidence in your trial?
Is it my understanding that they will supply me with a USB drive and then I am to review it while in court?
No, ma'am. So it's kind of a two-step process. So anything that's digital, that's not forensics or CSI or something that's tangible, will be provided to you on a USB drive. We also will have a hearing where all of the evidence, including any digital, electronic evidence, or any tangible evidence, CSI materials, will be shown to you in court, played to you in court, so you have the opportunity to review it here as well. Anything else will also be given to you on a thumb drive for you to review at your leisure based on the hours of 8 to 4 by the laptop at the Orange County Jail. And then we will have a deadline after we have this evidence viewing for you to identify in writing any objections that you have to any of the evidence that's been provided by the state.
So it's not a matter of any type of confidentiality, it is all done in the courtroom with everyone?
It would be in the courtroom, correct?
Are there going to be news cameras and photographers?
That's something I need to address. I do not want, because our jury pool is going to be coming from Orange County, I have concerns about the media's presence in the evidentiary viewing. So I may have to enter an order which would prohibit media access for the purposes of that hearing due to the nature of what is being produced and reviewed, so as to further prevent intimate details of the case being released prior to trying the case.
I understand that, Judge. Ms. Boone, not to turn the page completely, but I think it's pertinent to this discussion, has indicated through some counsel that had met with her recently that she wants to talk to the state out of the jail. And I was going to discuss that at the end, but perhaps to not waste the court's time, I don't know about bringing physical evidence out to the jail, but as far as the digital evidence, which will include autopsy photographs, which will include crime scene photographs, which will include videos, Perhaps a different suggestion, especially since she has an investigator from Prison Break, is that we identify those files that we intend on introducing at trial so that they can review that digital evidence on their own in the jail, and we're not publishing all the digital evidence here in open court. That should allow her the opportunity to lodge any potential objections, such as duplicative or any other objections she may want to raise about autopsy photos, so on and so forth, without exposing all of the digital media to the public. As far as the physical evidence, the state doesn't have any real concerns about the media covering that. She can open those exhibits, or somebody with scissors can open those exhibits for her if there are any exhibits she wishes open in the witness box where it's concealed from the media's eyes. So those are my suggestions, and then later we can turn to her request and put on the record how we would go about going out to the jail and meeting her.
The only concern that I have with that is I don't have a record as to what it is that she reviewed.
My suggestion would be that because this is in the context of plea negotiations potentially, I would be out there, Mr. Cacciatore would be out there, and our investigator would be out there, and we would record it. The conversation that we have, of course, and that would all be protected because it would be in the spirit of plea negotiations under the evidence code. And then we can all file in writing, the state can file in writing, these are the videos that we are going to use. These are the particular photograph numbers from the crime scene and from the autopsy photographs that we're going to use. And then we can have the defendant sign off on that as well, so that it's documented as to what was told that she would be facing at trial. And either she can review it with her investigator, or she can review it with us, being present, and then that way the digital evidence is now in the open.
Okay. Ms. Boone, what are your thoughts on that?
I'm a little lost. So it's an option of reviewing what the state has.
People, she's fucked. She is fucked. They're gonna have to, because he's denied counsel for her now, because the judge has denied it, which I think is a wrong decision, but that's up to him. She's going to be asking questions left, right, and centre. This is supposed to be a week trial. They've already said it's going to be 3 weeks. The fuck are we doing? She's going to be asking everything. She is going to be absolute pain in the ass. Absolute pain in the ass. For this, it's going to be torture. But I think she should have counsel that, and the counsel wouldn't be doing anything. The question she's got now for the judge is what the counsel will do for her, explain that. I just think that having someone to go, right, what does the judge mean with that? And he can explain it, is better than her asking the judge and the judge having to explain everything in open court all the time. I don't know. I think it's going to make the trial drag on a lot longer. But we'll see. Before I get back to it, hang on. Here we go. Ole, 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 ole. Erin hack, 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 ole. Erin hack, 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 ole. Let's go, Erin hack, 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 ole. Erin hack, 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 ole. I agree with Sarah as well. It'll be stop, start, stop, start, stop, start, stop, start, stop, start.
With my investigator, and then be able to come with the objections and everything.
That is correct.
I'm clear on having all of my evidence being in sealed bags, and for me to be able to inspect them to be here in the courtroom. I don't know how the attorneys have done any of this prior, but I don't believe that it was in the courtroom. So I'm just trying to protect myself against the media. I'm not sure at this point what is even suppressible that is available on the internet. But at the same time though, it is my understanding that I should have some right to privacy in reviewing the evidence. So I didn't know if my investigator and I are able to collaborate prior and view and then come to court with everything finalized and ready to go with answers.
I'm certainly going to give you an opportunity to meet with your investigator to address it. The question is just the method of how to do it. The state's proposal is digital. They would meet with you, identify specifically digitally what videos, what photographs they intend on utilizing, and anything that may be physical, CSI, etc., would be addressed here in open court.
Just so that the court and the defendant understands how physical evidence viewing would operate normally, the defense attorney and or her or his investigator would come out either to the sheriff's office or OPD's evidence center, whichever agency, and they come and view it, but it's done in the presence of the state, it's done in presence of law enforcement, it's done in presence of the CSI for the chain of custody. So attorneys don't get privacy when they're reviewing the physical evidence either. So that wouldn't really be any different than if she's doing it in the witness stand or wherever you deem suitable in the courtroom.
I think that's the most appropriate way to have the opportunity, ma'am, to review the evidence. I can't release that evidence to Mr. Lane to bring to the jail for your review because of the chain of custody issues concerning some of the physical evidence. So CSI would have to be here just like an evidence viewing at the sheriff's office or elsewhere where counsel just identified. And I cannot bring you anywhere else other than here, and I can't release you to anywhere else. So I think the only solution that we have is to have the evidence viewing here with regard to any of the physical evidence.
Why is it that it cannot be transported anywhere other than here?
Because I cannot make a record anywhere else of what you saw or what was reviewed. The only opportunity for me to make that record is here in court.
What did prior attorneys do?
That was already identified by the state.
I know I'm trying to keep up with everything. What was the answer, please?
So an attorney who's doing an evidence view would come out to the law enforcement agency's evidence warehouse, for lack of a better term. And then in the presence of the state attorney, the CSI, and the lead detective, they look at the package, and if they deem any particular package worthy of opening and examining, they can do that. We can have the CSI bring butcher paper here so that any particular item can be opened, put on fresh butcher paper, and then changed out between exhibits so that there's no contamination. And then you can examine it. If Mr. Lane or any other representative from his organization is here, he will have the opportunity to photograph those exhibits once taken out of the packages. And that's essentially how an evidence viewing is conducted.
Thank you.
You're welcome.
And again, please, would the media be involved in that?
That's a conversation that I need to see if I can exclude them from participation or viewing that proceeding. There are rights where the media has to view proceedings in court, but due to the sensitive nature of what may be being discussed or viewed, I need to see if I can prevent media access. So without doing a little bit more further dive or research in that, I don't know if I can make that call at this time.
Yes, I have not heard of a case where the evidentiary hearing has been televised. So if you could please look into that, because I disagree with the media being involved in that.
I understand your position, and again, for the reasons that I stated earlier, I'm trying to prohibit as much as I can from dissemination to the public, especially some of the exhibits that the state may be seeking to utilize. We are going to go ahead and set the evidence hearing. The first is Sunday. September the 1st is a Sunday, and that is Labor Day. The court would be setting a hearing for Tuesday, the 3rd at 9 a.m. to have the physical examination here in court. At that time, if the USB drive or the after our viewing here in court, state, is it your position to then have that meeting with Ms. Boone and her investigator and your investigator under the plea negotiations or settlement discussions auspices to review all of the digital and identify what it is specifically?
We are happy to defer to the defendant's wishes on that. And I wanted to have that discussion. It seems like we're turning that discussion. So I'll leave it in Ms. Boone's court. My indication from one of the attorneys that she had discussed things with said that she wanted to have a conversation with us. And so I'm offering that up. In the past, with female defendants at the Orange County Jail, there are classrooms, or at least one classroom there, where we could arrange to meet. It would be a big enough room for 4 or 5 of us that would need to be there. And then we can discuss that, whatever it is she wants to discuss, and it would be recorded. And again, those portions of the conversation that are about plea negotiations and the evidence and whatnot in the trial, I believe under the evidence code would not be admissible to be used against her. And I can leave it to her when she wants that to happen. We can make arrangements to try and accommodate that. It should not take us very long at this point, given the age of this case, to select and identify which digital evidence exhibits we're going to use. It's simply a matter of getting rid of duplicative and irrelevant photographs from the scene and the autopsy. And I believe the videos won't be too hard to decide which ones to use. I don't know that there's a whole lot of other digital evidence.
Okay. All right, ma'am, do you have a thought on when you would like this viewing to take place at one of the classrooms at the Orange County Jail under the concept as identified by the state?
So this meeting is separate. This is prior before everything else.
What I would envision, to not waste anybody's time, is we can go out there and have this discussion. If there is a discussion we had about plea offers, one of the other topics was other matters, so that's kind of ambiguous. I'm not sure what other matters are. And then also we can let her know and probably provide the court in writing a list of the digital evidence that we seek to introduce. And then that way, if she wants us to review those digital evidence items together with her in the presence of everybody, we can do that. Or we can let her, with the list of the digital evidence that we plan on introducing, review that as many times as she wants by herself and or with Mr. Lane.
I understand. So would I be leaving with the digital evidence today, or how soon may I receive that?
So the state needs to assemble that. So my thought would be to have that meeting, ma'am, on the 3rd of September. So we would have a hearing at 9 o'clock in the morning where the physical evidence would be reviewed here in the courtroom. As soon as that evidence was finalized and reviewed, the state with their investigator, yourself with your investigator, would then meet that afternoon at the Orange County Jail to address, as the state has identified or spoken about, any settlement negotiations, plea offers, and under the other category to address what the digital exhibits are. They would provide you those on a USB drive, and they would identify for them specifically what it is that they are seeking for you to review at that point in time and have the ability to review it afterwards.
We're happy to do that beforehand, and I just want clarification. By providing her the USB with all the narrowed down exhibits out of the discovery, are we providing it to Mr. Lane? How are we physically?
It would have to be provided to Mr. Lane,
okay,
who would then have to provide it to a member of the staff at the jail, the names of which I have from the captain at the jail as to what persons are involved in the laptop process. And then once that's done, I would require Mr. Lane to identify with a filing in the court, probably in the form of an affidavit, as to when, where, and how the USB drive was received by him, and when, where, how, and to whom it was delivered.
Thank you.
Your Honor, I feel uncomfortable with you supplying my evidence to the jail. So I don't know if there's a way that, I don't know if you are aware, but my jail phone calls have been released, and there's a lot of things that have been released from the jail. So I don't know, I do not feel protected by you all handing it to the jail. I know that Mr. Lane and I previously have worked on the laptop with USB drives that he has furnished himself from bringing in from the outside. So I didn't know, and I would feel more comfortable if there was a process or a procedure. I don't know who your names are from the jail. I do know the captain whom I spoke to the other day regarding my laptop. But I would very much.
Who was that, ma'am?
I'm sorry?
Who was that?
For which?
The captain that you spoke to. Who was it?
D. Giovanni.
Okay.
There's multiple sergeants involved, and I did meet the gentleman who was supposed to be here today to pick up the USB drives. So I don't feel comfortable, please, with providing the USB drive of my evidence with things that have been leaked or released from the jail. So if there's a possibility, please, I would like for my investigator to have that and bring in with me prior.
If I understand the jail's protocol, which I read to you at our last hearing, the jail will keep custody of the USB drives and release them with the laptop as well. So I don't know how I can bypass that process that they've created, because the USB drives and the laptop, when it's checked out by you and when it's returned by you, is all going to be logged in their IMS system.
Right, it's simply a laptop. It's a very basic laptop where anyone affiliated with my case has any type of digital evidence they bring in with them from the outside. It's simply a basic laptop that we are able to utilize at the Orange County Corrections Department. That's how we have done that prior. So I don't know what it is different, and I don't know the jail protocol because no one's included me.
You were provided a copy of it through the court filing, and I read it to you at the last hearing.
Your understanding is different than my understanding because my contacts from the jail are telling me something different.
Who? What are their names?
There's multiple sergeants.
What are their names?
I'd rather not get them involved with fear of harassment or anything from other.
Ma'am, I'm deferring to what the Orange County Jail and the captain that you identified specifically as to her memorandum to the court, which was read to you at our last hearing, which was sent a copy to you by a notice of service, and it was provided by U.S. mail. It was sent out last week.
I have yet to receive anything such as.
Don't worry, I have a copy to give to you this morning, just in case you have not received it.
Yes, the last thing I have is your order that you provided me with the implementation of your USB drive.
Okay.
Option.
All right.
So anything that you're speaking of in the meantime, I do not know, and it was served by process?
It was served by U.S. mail.
By U.S. mail?
Mm-hmm.
Yes. I actually have 3 motions, if I may submit them to you.
In a moment.
Yes, in the process of, because the address that you are, I'm guessing, sending these to is incorrect.
I received your letter addressing the address issue. That's been remedied. So the appropriate legal mail address will be utilized. It was simply a clerical error, and that has been remedied. But regardless, I did read to you at our last hearing the protocol for the USB drive in the jail. The court is inclined to follow the Orange County Jail's protocol with regard to the USB drives. So the evidence, digital evidence that the state seeks to admit at trial will be put on a USB drive, delivered to Mr. Lane. That will be delivered to a representative from the Orange County Jail. And Mr. Lane will thereafter file a filing with the court in the form of an affidavit identifying when he received it from the state and who he gave it to, when he gave it to, and what representative of the jail he gave it to.
So it goes from the state to Mr. Lane to the jail.
For the purposes of indexing it, for the purposes of their records under the protocol, and then it will be available for your use.
So if I want to see all of my evidence digitally, I need to contact someone at the jail.
No, ma'am. The evidence that were in the 2 bankers box that Mr. Lane digitized for you is going to be provided to the jail. That's going to be provided with the laptop to you. And that's available to you from 8 a.m. to 4 p.m. every day in the protocol that I read to you at our last hearing.
Yes, and I will speak to the captain just to be aware that everyone that it is in the process, because I do not feel comfortable with any of this, and I do not feel protected either by the courts or the jail system. So for right now, I don't know if it can be postponed or if it's something that I need to write another letter to. It everything takes longer in jail. So by me trying to get a hold of the captain nonetheless, is going to be a feat in itself. So I want you to know, if anything, that I am in the process of trying to reach out to the captain. I don't know if she'll be here today or if it'll be the contact person. So in the process, I am working on speaking to the captain because I do not feel, like I said, that I am protected in any way, shape, or form by the Orange County Corrections Department who have been withholding my evidence in any way, shape, or form.
Okay. The court's going to follow the procedure as I outlined at the last hearing. So here's what we will do. We will, on Thursday, September the 3rd at 9 a.m., we'll have a hearing to review the physical evidence. At that time, the state will provide its exhibit list, which will be filed with the court at that time, and a copy will be given to Ms. Boone of the physical and the digital evidence they are seeking to admit. After we have the in-court examination of the physical evidence, that afternoon, there will be a meeting at the Orange County Jail between the state, its investigator, Mr. Lane, Ms. Boone, to review the digital evidence and provide a USB drive with that information.
Again, caveat in that order being, unless it hasn't already been done. In case we do it ahead of September.
Sure, if you want to do it before, the deadline to do it will be to September 3. But the in-court physical examination will be at September 3. So if you all want to meet in advance of that, I won't prohibit that. Just file something in the court file identifying a notice or some document so that it identifies when that meeting took place, when the evidence viewing took place. Okay, thank you very much. Ma'am, after we've had this hearing on September 3, and that being the deadline for the digital evidence and the viewing of the physical evidence, the court would then like to set a deadline for when you would provide your objections to the state's exhibits. Mindful that this will take place on September 3 and that we have pretrial set for September 26th. And if we need to have a hearing with regard to those objections, my thoughts would be to give you 2 weeks until the 17th to lodge your objections. And those would need to be provided in writing by the 17th. So that if there are objections and if we need to have a hearing on them, that hearing can be held when we have our pretrial on the 26th. That would give the state ample opportunity to prepare for any of the objections that you have.
Forgive me, and thank you for your patience, everyone. So on September 3rd, I will be viewing the digital and physical evidence here in the courtroom.
Correct.
And then later that afternoon, I would be meeting with the state and my investigator.
If they don't meet with you prior to that date. The deadline for the state's investigator, your investigator and yourself to meet to review the digital evidence would be no later than the close of business on September 3. I've outlined for when I would like it done, but if the state wants to meet you in advance of that date, they can do so.
Yes, please. If I may ask, please, what is your name, sir?
William J.
Could you spell your last name, please?
J-A-Y. Don't get asked that whole time.
And what is your affiliation with the state?
I'm the homicide unit chief.
Yes, please. And I am okay if you would like to meet prior, so less time is consumed on the day of our meeting, supposedly on the 3rd.
So I assume you have availability. Should I meet with Mr. Lane to discuss his availability so we can get out there this month?
Yes.
Then you can do that. And like I said, Mr. J, if you could follow that notice, just identifying when, that would be most appreciative. So ma'am, understanding where we are with the viewing, what is September 17th for the deadline for your objections acceptable to you?
Yes, and if I may please raise the point that I have a motion here in regards to going in the process of working on it for the laptop. I do not have my discovery as of yet, and I do not have the laptop as of yet. I do not know what hiccups may be involved. There's a lot of hiccups with the jail already. So I'm trying to figure out when and where I'll be able to view anything. So there's a great restriction also that is being put on the laptop usage from 8 to 4. I'm unable to utilize my time to the full extent. Also, I have a motion here to receive my hard copy evidence because when the laptops are in quotes, the laptops in quotes, closed for the day at 4 p.m., I can therefore pick up using a hard copy evidence.
I haven't had the opportunity to review the motions that you're speaking of, neither has the state. We'll address them today. I don't have a problem doing that. I'm just not going to do it right this second because I haven't had the opportunity to review them yet.
Yes, and I'm just explaining myself in the meantime, please, so you're aware of what I have already thought of and am trying to ease the pain of everyone with me trying to figure out how to do everything and when and do it appropriately. But I just wanted you to know that by bringing that topic up, I have that to also be looked over.
Okay.
Please. 9/17, if that has to be changed, am I okay to do that?
I'm trying to set deadlines now, ma'am. And that will give you 2 weeks to review the physical evidence. You'll be provided the digital evidence, it seems, in advance of that September 3rd deadline. And that may give you more than 2 weeks to review and lodge any objections.
This is just for the evidence?
Correct. This is only addressing any objections to the evidence that the state seeks to admit.
The digital discovery, is any of that included in that?
Yes.
Okay. I am very weary to make any type of deadline.
Well, we're setting them today,
I understand. So the 3rd is a what day? Thursday?
Tuesday. So the 17th would be 2 weeks later, Tuesday the 17th.
And that is me coming with my objection.
That would be you filing your objections in writing with the court. And to the extent we would need to have a hearing on those objections, we would have them when the pretrial or trial case management conference is set at 9 a.m. the following Thursday, the 26th of September.
I'm sorry, what is on the 26th?
That's when we're having our pretrial or trial case management to address any last minute issues regarding trial.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
You have 62 days to prepare for trial, not including today. And you're going to get your discovery today.
Wow. So in over 4 years, it comes down to me representing myself in 62 days?
I'm not going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th. And those objections will have to be in writing. If we have to have a hearing on those objections, that hearing will be held on September 26th.
Okay. And if I may ask, are these being delegated or I'm being incorporated in this in order for me to be able to say yay or nay?
I don't know what that means. What do you mean delegated?
Are you delegating to me as you've delegated everything else in regards to taking my counsel and all of your orders?
You are representing yourself for the reasons that the court identified in its 16-page order. It is your responsibility, as you are representing yourself and proceeding pro se, to comply with the court's orders and deadlines. So if you have objections to any of the exhibits that the state may be seeking to offer into evidence, be it digital or physical, based on your review of those, the deadline to submit those in writing would be on September 17th.
Okay, so you're making statements, so I don't have any say in it.
I've asked you what your thoughts would be as to when. You've never provided me in a disagreement with regard to that date as of yet. You've asked questions about your motions that I haven't seen yet. Your desire to have hard copies, which we addressed at the last hearing, but I'll be glad to address it again today. You have yet to tell me that that date's unacceptable for you, and if so, why?
I wouldn't necessarily say unacceptable. I'm just uncomfortable with agreeing to a date when I am pro se and have never been pro se before and do not know what I'm doing. So I just want to make sure that I do it correctly and have an understanding also, if you are proposing that I go to trial within 62 days, that I know what I'm going into and what I may expect. So I didn't know if this would just be easier on everyone else, if they just delegated the dates and gave me a printed copy with your order and whatever information you have. I don't know. I don't know either if you all are just proposing that because I'm incarcerated, just the dates are what you tell me. I don't know what I'm doing. I do not know what I'm doing. So I'm trying to learn as I go, which is why I'm grateful for everyone's patience. But at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that question. Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Okay. Well, I'm with the court, so whatever it is that you all are trying to do in order to expedite this even more than what it's being expedited, I'm guessing I agree with September 17th.
Okay. Now, ma'am, I believe that takes care of all of the deadlines with regard to the state's exhibits. Now I want to address deadlines for any exhibits or witnesses that you may be seeking. I am mindful that you will be receiving the discovery today and that you have not had the opportunity to review some of the items that may be in the discovery. So how much time would you like to provide to the court the list of exhibits that you may be seeking to enter and the list of witnesses that you may be seeking to have testify in a defense should you choose to put one on?
Please understand that I do not have access to a normal phone. I don't have access to a normal phone at normal hours. So I am trying to overcome the hurdle of trying to, number one, locate any of my witnesses, and then also try to communicate with them on a payphone only telephone call that I do not have regular access to, and that are limited to only 15 minutes that I have to share with 62 other inmates. That is a hurdle, please, that I need you to please take into consideration in order for me to be able to try to determine my witnesses, to determine any expert witnesses. May I ask, please, does the laptop have internet access?
I'm unaware. I'm unaware if it does.
To view any documents?
I'm unaware. I can't answer the question that I don't have an answer to. I'm unaware if it has internet access.
Whom is it that I need to speak to in order for this?
We may be able to inquire of the jail representative who is appearing for the hearing this morning, and if not, the captain may be able to provide that information, but I do not know if it has internet access.
May I ask your contact names from the jail?
Give us 1 second.
Please, and also because of the court's error of sending my information that you're referencing to the incorrect address, could you please provide me a copy of that also?
What is it that you're asked? Which, the protocol, ma'am? That was what was most recently sent.
I don't know. Whatever it is, the last thing that I received from you in the court was the hand delivery of the order regarding
Sure.
USB.
I have a copy that Madam Clerk's already printed out of the protocol. We will have the deputy hand deliver that to you right after. What I did. Yeah. Oh, I sent it to Anita. That's why. Give me a second. I'll have Madam Clerk print that out for you right now, ma'am.
Thank you.
So, understanding that as of right now, you do not have hard copies. You'll be provided digital copies. And to review all this evidence, ma'am, when in time do you feel comfortable in providing the court and the state the list of your witnesses and your exhibits that you may be seeking to introduce?
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and fundamental equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I will be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain so I can see if I can have access to a regular phone, if I can have access to an internet. Right now I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have access to the phone. I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
If the defendant's not going to make a suggestion, maybe state.
Sure.
My suggestion would be to give her 14 days after the point that the specific evidence identified by the state to be used at trial is provided to her. So, for example, the physical evidence, which we plan on giving her the list of those physical items well in advance of September 3rd. That will just be the date that she can actually see them. But my suggestion for those physical evidence items would be September 17th, and then 14 or 15 days after whichever day we get the specific list of digital evidence items to her, would be our suggestion.
Okay. Ma'am, are you amenable to that? That would 14 days after you've had the opportunity to review the digital evidence and 14 days after you've reviewed the physical evidence to provide your exhibit lists?
I don't feel comfortable with any of this. I don't have the same opportunities as the state or any attorneys prior. So I feel that you all are pressuring me and forcing me into these dates which I may not be able to meet or exceed.
Can I add that obviously either side, if there's good cause for why a deadline wasn't met, if something comes up, then we're not prohibited either side from complying with the rules of discovery afterwards. But there would just need to be a cause shown at that point.
Do you understand that, ma'am?
I do.
That I'm setting these dates for now, and if either party can establish good cause why these dates should be moved.
Yes, and that is why I'm trying to make everyone aware prior to all of this to understand my circumstances by being incarcerated and not having access to a phone, not having access to the internet, and not having access to many more other, like I said, basics, fundamental basics, which is why I'm making you all aware now, so you are aware that when the time comes, should it, why for good cause, I'm stating my good causes now, if not, there are additional at that time.
Ma'am, as of right now, the court is inclined to agree with the state's suggestion that 14 days after viewing the digital evidence, which will take place no later than September 3rd, sounds like it'll take place way in advance of that, you are to provide in writing your list of exhibits that you want to attempt to move into evidence. 14 days after viewing the physical evidence on September 3rd, you are to provide in writing the list of any exhibits that may be physical that you intend to enter into evidence. Those dates can be extended for good cause that may be shown. State, would you like the opportunity to review those exhibits similar to an evidence viewing that we're having with Ms. Boone reviewing the state's exhibits? Would you like a similar opportunity to review any of her exhibits?
If the defense has any physical evidence to place in evidence, I can make those arrangements with Ms. Boone.
Okay, all right. I will set a deadline for the review of September 26th.
Thank you.
Is the review that you're speaking of, please, for my exhibits and witness list?
That is correct. I would also propose a similar date of September 17th for any of the witness lists for the defense. And Mr. J, would you be in a position by the 1st of September to provide any witness lists for the state?
She should have the witness list in the discovery that's being provided. As far as the order and the list of witnesses that we're going to call at trial, we will get in that ahead of 9/3.
Okay, all right. So the deadline for the state's production of the witness list will be September 3, no later than, and September 17th for Ms. Boone. Ma'am, similar to the objections to any discovery, that'll have to be in writing as to who it is that you may be calling as a defense witness. You'll have to provide that to the court in writing by September 17th.
Yes, and if I may ask, please, what you're typing, is that for an order or for today's proceedings?
It is for an order, which you will be given a copy of. It may not be able to be hand delivered to you, ma'am, because I'm gonna have to move some stuff around based on my scratch notes here, but at a minimum, it would be mailed to the your proper address. Due to that clerical error, that will not be an issue.
Wonderful, thank you.
Okay, I think that addresses all the issues with regard to production and hearings on any objections. Anything else from the state that you believe we need to address from a scheduling concept?
We're good with the scheduling concepts. Thank you, Judge.
Thank you. Ma'am, do you have any questions with regard to the scheduling concepts or deadlines that we've addressed this morning?
Other than what I have made known to the court, I do not.
Okay. Bruce, can you see if Mr. Sergeant Casey's here? He is here.
Your Honor.
All right, very good. Sir, could you come on up, please? Madam Clerk's going to go ahead and swear you in.
I love the fact that the courtroom, wherever he is called Bruce. We got good day, Bruce. That's going to be a thing we're going to do every day. Good day, Bruce. Make sure Bruce is there.
You can stay at the podium, sir. No, just the podium, Sergeant.
Oh, sorry.
If you could raise your right hand, Madam Clerk, can go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Sergeant Casey.
And what's your position at the Orange County Jail?
Sergeant.
And what are your duties and responsibilities, sir?
I'm over transportation, downtown port holding, BRC courts, medical security, and the juvenile assessment center.
Okay. Are you aware of the protocol that Captain DiGiovanni created with regard to Ms. Boone's use of the laptop?
I am.
Okay, all right. Have you had the opportunity to review that protocol?
I have.
Okay. Mr. Lane, can you come on up here, please, sir? Sir, good morning. Could you raise your right hand? Madam Clerk's going to swear you in.
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, sir, good morning. Could you state your name for the record for me?
Willie Lane.
And what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
All right, sir. Last time I saw you, I had tasked you with digitizing 2 bankers' boxes of information. And you said that you would endeavor to accomplish that task by today, understanding that you were out of town for your son's wedding. I hope you had a great time. Were you able to fulfill that task, sir?
Yes, sir.
Okay. How many jump drives or drives do you have?
Of the digitized information, there's one of those. This drive here is a copy of all digital discovery that I have in my possession from Ms. Boone for the court's needs if they wish to facilitate that through the, figure it'd be easier to facilitate it now through the jail than me trying to bring it in myself.
That's exactly my thought. So you've shown to me, sir, a small thumb-sized USB jump drive. That USB jump drive is the information that was contained in the 2 bankers boxes, correct? And the other jump drive that was the larger of the 2, that jump drive is any digital information that you've had previously by virtue of being the investigator.
Yes, sir.
Okay, all right. The record's going to reflect that information is going to be hand-delivered by Mr. Lane to Sergeant Casey. So Sergeant Casey, you can please take custody of those 2 thumb drives. And I'm going to ask you, sir, to comply with the terms of the protocol, to have those added to the laptop and be available for Ms. Boone's use today once she's returned to the Orange County Jail. Do you have any questions for Mr. Casey?
No, Your Honor.
Okay, sir, thank you very much. If you can proceed with that task, I appreciate you. Thank you. Mr. Lane, you took custody with you, sir, as well. Well, before you leave, Sergeant Casey, state, do you have any questions for him?
No, Your Honor.
All right, ma'am, do you have any questions for Sergeant Casey regarding his compliance with the protocols provided to be by the captain of the jail?
Mr. Casey, could you please make note to Captain Giovanni that if she has time at some point, as soon as possible, to please sit down with me for about a half an hour to go over quite a few things that I need to have resolved.
I'll look forward.
Please, in regards to the laptop.
Okay.
Thank you.
Thank you very much, sir. Mr. Lane, when we were last here, you also had 2 bankers boxes. Did you bring those back with you, sir?
Yes, sir.
Okay, could you bring those back up? I do see it looks like the original exhibit tags are still on the top of those. Mr. Lane, did you complete and copy everything that was in both of those boxes?
Yes, sir.
Okay, I'm gonna have Madam Clerk take possession of what was pre-marked as A and B for the purposes of the June 28th hearing, and we'll hold those into evidence. Do you have any questions, Mr. J, for the investigator with regard to his task?
No, Your Honor. Thank you.
All right, ma'am, do you have any questions with regard to your investigator regarding his completion of the digitization process?
And my only question is, Mr. Lane, do you know when you would be coming to meet with me at the jail?
It's going to be my intent to try to get out there at the end of the week or beginning of next week.
Thank you.
Thank you, sir. I appreciate you.
One housekeeping thing.
Yes, sir.
I don't know if Mr. Blake, since he's here, would like me to sign my invoice or have Ms. Boone do it since she's pro se.
I don't feel comfortable signing your invoice. I think Ms. Boone would have to sign it.
Okay, that's fine.
Okay.
Is it okay if I?
Hand it to the deputy. Deputy will have her sign it, and then you could take it. Mr. Lake, is that acceptable, sir? Counselor, you're muted.
Yes, that would be acceptable, yeah, if Mr. Lane, and Your Honor, in light of this, maybe it might be more appropriate for the court to go up to 10,000 for the investigator, because it sounds like he's already done a lot of work. So it might make more sense instead of having to come back later.
Would that change the original, the 5,500, or just we would increasing 5,000 to 10,000?
5,000 to 10,000, I think would make sense, Your Honor, just because it sounds like that we may, based on what's already been done, and Mr. Lane may have more to say about that, but based on what he's already done, I suspect he's probably used a large chunk of that 5,000 just doing this one task.
One thing I would like to add, Your Honor.
Yes, sir.
In lieu of having to come back and file another motion, is if JAC would agree to travel expenses since I'm out of county. If not, I can get that in some type of form of a writing and get it to you or to the JAC if that's acceptable.
Mr. Lake?
Your Honor, we'd have no problem with the court authorizing, saying that $1,000 for travel expenses as well.
All right, fine. So we'll increase it from 5,000 to 10,000 for investigative costs, and for travel-related expenses, 500 to 1,000. Mr. Lake, are you going to need an order for the court file with regard to those?
We would, Your Honor.
Okay, could you submit that?
Yes, Your Honor, we will prepare the order and submit it.
All right, very good. Just send it to Ms. Barrios, who I believe you have her contact information.
Yes, Your Honor.
All right, very good. Thank you, sir. Mr. Lay, thank you so much, sir.
Yes, sir.
All right.
Judge Keenan,
Yes, ma'am.
forgive me. What is his name, please?
That's Christian Lake. He is an attorney associated with the JAAC, the Judicial Administrative Commission, regarding costs for indigent defendants. All right, state from a scheduling perspective or the protocol, which I know I filed a notice of filing of, I'm sure you've had the opportunity to review it. Anything else we need to address from that?
We're good on scheduling, Your Honor. Thank you.
Okay, thank you. Ma'am, anything else we need to address regarding scheduling or the protocol other than what you've already addressed this morning?
Will my investigator be present at anything for and with me?
I can't speak to for or anything, but based on what we discussed today, your investigator will be there for the digital review, which will take place no later than September 3rd.
Okay, yes, I would like to have some type of witness from
He will be
the
there.
site also.
He will be there. Mr. J is going to be recording the conversation as he identified previously.
Thank you.
Now, ma'am, you made reference to some motions that you may have brought with you this morning.
Yes, please.
All right, if you could hand those to the deputy. Also, to the extent that the deputy has not already done so, I printed out a copy of the July 24th, 2024 protocol regarding your use of the laptop at the jail. And I'm going to ask the courtroom deputy to please hand deliver a copy of that to you. It was mailed to you. It was read to you at the last hearing, but now you have a physical copy of it, ma'am, to the extent one was not already provided to you.
Oh, yes, I have not received this yet.
Okay.
And then also there was another printout that she was going to provide me with, which I believe was a memorandum for today's date.
I haven't, is she being who, the captain?
No, I'm not sure her name.
Oh, Madam Clerk, no, the only thing she's printed out for you right now, ma'am, is that protocol. I'm going to be finalizing the order. And like I said, I may be able to finish it before we're done with the hearing, and I'll hand deliver it to you. If I cannot, it'll be mailed to you.
Yes, I understand. It was regards to another document proposing the dates for today's hearing. And I guess it was some type of notice. That's what please that she was going to print out to give to me, so I have that.
Okay. Mary.
I did not receive that, nor did I receive this protocol list.
As to everything that was being discussed, can you print out a copy of it first? It should be in the court file. All right, ma'am, let me take a moment to review your motions. Give me a moment here.
Thank you.
I do find this fascinating, the whole thing. I think it's really fascinating how we go through all this. I mean, whatever you think of her, she's ballsy as hell. She's got a set of balls on her. You know. I don't think anyone's going to fuck about with lawyers in the future. 11 o'clock, I believe. 11 o'clock, I believe. I'm still trying to find a link.
That's been remedied. So I'm going to go ahead and grant that motion as that's already been remedied, but I don't have a problem granting your motion for the correct address for any legal mail.
Thank you, Tim and Susie. I hope the weather's okay with you in Florida, Tim and Susie. Thank you so much for the super chat, Tim and Susie. Much love to you both. Thank you, guys. Hey, Delal, thank you for always being there for us. We love you. It's Susie and Tim. Thank you very much. Tim, nice to see you again. Much love to you, Susie, as well. See you, Huckster.
Mr. J, if you want to approach, sir, to review the hand-delivered motions, it is the motions for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom. Second motion is the motion for defendant to lawfully receive, review, utilize the original hard copy discovery, parentheses, 2 boxes, -A, B, parentheses, submitted to the court by former attorney, parentheses, S, and parentheses, on June 28, 2024, for preparation of trial in her criminal case. Just review those, Counselor, and just let me know when you're ready to address them.
Thank you, Shari.
Your Honor, in regards to the first motion, we need to notice the sheriff's office, who is in charge of courtroom security. So we're not able to address that today unless they're allowed. I don't know if you're able to contact the person that's in charge of that today. Otherwise, we would need a separate day for that motion.
Okay.
As far as the second motion, it's completely up to the defendant. We have no standing to say anything about it. If she wants to have her documentary discovery in hard copy form, that's between whoever and whoever, but not the state of Florida.
Okay, all right, I appreciate that, sir. Ma'am, with regard to your request for discovery, the hard copy discovery, you've advised me multiple times seeking to use a laptop. I've written correspondence from you asking for a laptop. That laptop is being provided. At the last hearing, you advised that you wanted hard copies. You've also advised me that you live in the female dormitory, you have limited to no privacy, and you have nowhere to store anything. You have a small drawer to keep personal effects, and that's it. There's nowhere, is my understanding, in communications with the captain to place this information. There's nowhere to house it. There's nowhere to store it. You do not have, by your own admission, any place to place it.
Is that your understanding now? Are you asking me?
No, those are just statements that I know that are in the court file that you've made. You've written letters requesting a laptop. That's been provided to you.
I've never.
You have written letters, ma'am, specifically asking for a laptop.
Do you know what the date of that is?
Without me going through all the correspondence. But when we have our hearing on the issue of the your motion for freedom and movement, well, I'll notice the sheriff, and we'll try to set that up for this week so that it can be done expeditiously.
Okay.
We can address that at that time. But the jail has advised me they have no place to store this information, these hard copies. You've advised me you have no privacy and nowhere to place them. So I'm not saying no, but I don't know how I can facilitate this for you. When you do not have a place to store it, the jail does not have a place to store it.
We have an entire property department for all of the inmates on the entire compound. I've been given permission also by Sergeant.
Who?
Corporal Ward, Sergeant Dunn, Sergeant DeJesus, had the understanding that I have been forced to represent myself as pro se and have temporarily given me a property bag where I can store additional case documents at my bunk. Help me understand, please, for future reference, so I know how to approach. By my statements that I have made to you, questions were not asked in order for you to come to the conclusion that you are coming to that I did not want my hard copy. I was never formally asked by you to see if I wanted my hard copy discovery. I would believe it was the court's understanding, the judge's understanding, that it should automatically be allowed to give to me. My understanding and trying to explain to you also, so you have an understanding, is my limited restricted access to the laptop is from 8 to 4. I, with 62 days left in order to defend myself in preparation for trial, would like to close that laptop at 4 p.m. and then pick up the discovery of hard copy in the 2 boxes that I have. I haven't spoken to the captain yet. I just now received the protocol for the laptop. I know that you had mentioned it to me the last time that we met with one another. So I'm confused how everyone is confused by me coming to the court with solutions and ideas and suggestions, but are being misinterpreted and misconstrued like my letters from my attorneys, and you're coming to the wrong conclusion.
I'm not coming to any conclusion. The process was created And I'm just reciting what you've said to me at prior hearings, ma'am. That's all I'm doing. You've told me you have limited space. You've told me that you have no privacy and that you have a small drawer for personal effects. This is the first time I've heard anything about you having a locker or some kind of bag or property bag that you now have access to. That wasn't addressed at our last hearing. This is the first time I'm hearing about it. So I'm not drawing any improper conclusions, as I identified for you with the process. The jail created this process. It was something that they put together. And as I told you, we worked diligently to move forward to get with the jail to have this done. There's no nefariousness here. There's no undermining. There's nothing along those lines. I want you to have this information. And as I addressed at the last hearing, I could not copy it. I can't look at it. I can't look at what's in those two bankers' boxes. Ms. Berrios cannot. No one associated with my office can look at it. We had to use your investigator to do that. And what the jail has advised me is that they were not in a position to take both those bankers' boxes because of space and potential hazards. Now, if something has changed and the captain advises me that you can have those documents, I don't have a problem with you having them. But what I've been advised, as identified in that protocol, is to how and when you can have access to the information. And unfortunately, it wasn't in physical form, it was in digital form. And that was the process that the jail created. They are aware it's two bankers' boxes. They're aware of what the information is. Everything has been out in the open to address your concerns and how to facilitate getting this information to you. No one's withholding anything. No one's trying to hide the ball.
My opinion differs. I was never asked anything, just like my letters to you prior to you forfeiting my right to counsel. I was never asked anything in order for you to have a better understanding.
Ma'am, I'm not going to revisit that.
I am not, you never asked me in regards to the hard copy.
Hang on. Yes.
How quickly can we have an evidentiary hearing with the captain or whomever we need?
My understanding is she's on vacation this week.
Okay.
So, which is why Sergeant Casey was here, because Captain DiGiovanni is on vacation. And I cannot recall off the top of my head when she's set to return. She's set to return on the 12th.
So if the document, what would be the process? Because it's marked, tagged, and in evidence. So there would need to be a motion to get it released from evidence.
I mean, I would entertain an or tennis motion to have it released from evidence. The concern as, and Mr. J, this is the first time I had the opportunity to discuss this case with you. I know I've been dealing with Mr. Cacciatore. We had a hearing, and I'm sure you're versed on this, but let me just kind of bring you up to speed. We had a hearing in June, and at that point in time, I forfeited Ms. Boone's right to an attorney based on her conduct and alternatively a waiver. And I'm sure you've read it. Thereafter, the court endeavored to figure out how to get those two bankers' boxes that Ms. Cashman had provided to the court at that hearing in Ms. Boone's possession. It took time for the jail to come up with a policy and a procedure for that to happen. I was advised by the captain that they could not take custody or possession of those two bankers' boxes because of A, storage, and B, because of the hazard. Now, if the jail's in a position to revise that by virtue of Ms. Boone identifying a property bag or something that may be available for her use, I am 100% on board. If the jail says, yeah, we can facilitate and make that happen, her getting that information. I'm just traveling with what I've been provided, and the protocol that was provided to me that's been filed in the court file was not inclusive of providing her hard copies.
I understand. I'm just trying to find a solution. So
Same.
If she moves or tennis to release those two exhibits to her investigator, then perhaps he can try and get them released to her. And if he cannot, then it sounds like on the 12th, we can revisit this when the captain's back.
I think I don't know if she returns on the 12th or that's when her vacation ends. It's a Monday, so I'm assuming she'll be back, but I don't want to make any affirmative statements on that. I don't have a problem. Mr. Lade's had this discovery. I don't have a problem with him taking custody of it again. And if he's able to deliver it to the jail and they allow it to be released to Ms. Boone, I don't have a problem with that. I have no problem with it. I'm just traveling on what the jail has advised the court in the creation of this process.
I'm just So if she wants to ori tennis, which means oral motion, move to release those two exhibits. The state has no objection, and it sounds like if Mr. Lane can't get them to her, we'll be able to revisit this in the near time future.
Yes.
Just so that she's advised. So I don't want to ask her, but perhaps the court can ask her that question.
Ma'am, the state has recommended a position in an attempt to get you these hard copies. Is that something that you would like the court to, would you like to follow with the state's suggestion and ask of that of the court orally this morning?
I'm not understanding what it is that he's trying to do. May I please propose that the hard copies go to Mr. Lane, and then once I have permission by the captain and whomever, you can release them to me?
Granted.
No objection to her motion.
Okay. Mr. Lane, thank you for staying, sir. I appreciate you. If you could come back up here, sir, and take custody of both of those banker's boxes. I will have Ms. Barrios coordinate a hearing for the 13th at 8:45. Why not? We cannot do it the 13th because it's pre-trial. You're correct. We will have a hearing on August 14th, if necessary, on Wednesday, August 14th at 1:30, if we need to address the jail's position in taking hard copies if Mr. Lane's unable to have it delivered. And Mr. Lane, you had advised earlier when Ms. Boone had inquired of you as to when you might be able to go visit her. You said the end of this week or by next week. If when you go to visit her by the end of this week or next week, bring that with you and see if the jail would be in a position to take it. If they are, I'm going to ask you to file a similar notice, sir, that that information was provided to the jail on what date and to whom. Okay. All right. Thank you.
Your Honor?
Yes, ma'am.
What would the hearing be for on the 14th then, for the jail taking?
The hearing on the 14th, ma'am, would be if Mr. Lane is unable to have the jail take physical custody of those two boxes for your review outside of the laptop, we would have a hearing to address what, if any, protocols the jail may be able to utilize in you having those documents. It may not be necessary. We're going to go ahead and set it if we need it. If we don't need it, we will not have a hearing.
Thank you. And then so there would not be needing to be made an updated evidence control sheet right now. It has been tossed to Mr. Lane.
As of right now, the court minutes are going to reflect that what was pre-marked as A and B from the June 28th hearing is being provided to Mr. Lane.
Thank you.
Okay. With regard to your reasonable freedom motion, I'm going to set that for this Friday. Is the state available at 8:45 on Friday?
No, what's that date, please?
That is the 9th, ma'am.
We're available, Your Honor.
Okay, Ms. Barrios will coordinate with a representative from the Orange County Jail to address the reasonable freedom motion. Ma'am, I'm going to hand file both of these motions with Madam Clerk, okay?
Thank you.
All right. Is there anything else we need to address this morning, State?
Not from the state.
Anything else we need to address, Ms. Boone?
Please bear with me, yes, please, one moment.
Uh-huh.
What was the conclusion for the sensitive issues of having the media incorporated in the courtroom?
I need to research that matter a little bit further before I can make an order that would prohibit media access.
Do you know what your deadline may be or estimated?
It'll be well before the 3rd. That deadline is set for September 3rd at 9 a.m. when we'll have that viewing. I will endeavor to get that done as quickly as possible. Ma'am, you also had asked for a list of the persons that Captain DiGiovanni had provided. The names of the persons at the jail regarding the laptop protocol is Captain Giovanni, Donald Casey, who was here this morning, Stephanie DeJesus, Sonia Robinson, Courtney Battle, and Malik Muhammad.
Thank you for that. Would you be able to provide me with a hard copy?
I will put that in the order that'll be mailed to you, ma'am.
Wonderful, thank you.
Okay.
If I may, I don't know if I'm allowed to address the state directly.
Yeah, you're representing yourself, absolutely.
How do I go about getting a copy of my phone or utilizing my phone? Is that something that can be brought to the courtroom and during the evidentiary, the physical evidence that I might be able to utilize that?
my understanding is there was an imaging done on your phone with software called Cellrite, and that is part of the digital discovery that has been provided to you. If you are talking about the physical device being re-examined by your own expert, then you would need to find and retain your own expert to do that without giving you legal advice or suggesting that he is the person you hire. I know that defense attorneys in this area hire somebody named Richard Connor, C-O-N-N-O-R, and then that will be between you and the JAC and him, whether or not he wishes to work for you and at what rate, so on and so forth. And then that examination would be done by him, with us being present if we want to be present.
Yes, I have reviewed, I believe, 2 or 3 different thumb drives were given to me at one point, where I researched all of them extensively, also included with Mr. Lane, and it is nothing of use. It's primarily cookies and history and so forth. So that's why I don't understand who it is, the legal expert that can give me a near download of my entire phone in regards to videos and pictures and contacts. I could probably supply a witness list sooner than later if I were to have accessibility to my phone in regards to my contacts. That's why I didn't know if it would be allowed to have my phone physically here in the presence of everyone, including law enforcement, to be able to physically look at my phone and go through it and to see what I can extract myself while here in the courtroom before trying to figure out how to locate and contact an expert to download all of that to receive.
So all that information should have been downloaded, and I'm not sure what has been provided to you, but we will be double checking that.
It has not been provided.
Yeah, your contact information, all the videos and photographs, everything on your phone should have been downloaded. And what you may have reviewed is just a PDF file called the timeline. But there is additional data there, and we will make sure you have that. And then when it comes time to our digital evidence deadline, which I hope to exceed well before 9/3, we will be identifying which portions of it is of your phone, if any, that we seek to introduce at trial. So it may be texts from December 2nd, 2019, whatever it is. We will identify those pages, we will identify those files, because obviously your entire phone, however many gigabytes it is not going to just come into evidence, because like you said, there's so much of it that would be not relevant.
Yes, thank you. So you all have already had access to my phone and have researched it fully?
We're not going to talk about our work product. I'm telling you what, based on my experience from other phone examinations is, all that information should be there. And it's typically presented in 2 different fashions. One is a large PDF, typically hundreds or thousands of pages, depending on how much you use your phone every day. And then there's a separate big digital image file that is read with what's called a UFED reader. And then that is where you can go in and look at everything.
Yes, sir, thank you. I've not seen any of that.
We were going to make sure that that is taken care of.
And that, just as clarification from the court perspective, is that something that would have been provided in discovery to prior counsels?
Yes.
Okay, then ma'am, as Ms. Cashman identified, she had everything. It's already been digitized for you. And to the extent you're able to have the hard copies, it'll be provided to you. So you'll have access to all that information today when you return from the jail.
Yes, thank you. None of it was gone over in any way, shape, or form with Ms. Cashman or any prior. So this would be a milestone, an epic milestone for me to be able to finally do that. So now, if I don't have what I need or I'm looking for, how do I go about? I know you all can't tell me because of legal matters, but do I need to write a motion? I don't know what I need to do in order to finally get a copy near download of my phone. If it could be brought to you for physical, with the other physical.
So again, that is going to be something that requires an expert. And then if you get a defense expert, and the JAC pays for it, then we make arrangements to meet with that expert. That expert will have the opportunity to image your entire phone just as we did, and you all can work with that image. And you're going to be, if you don't already, on those thumb drives that Mr. Lane has, if you don't already have the full extraction and not just the PDF timeline, of your phone, we're going to make sure that that is provided.
Okay, so that is not able to be included in the other physical evidence that you will supply?
No, what I'm saying is there's two different ways that I see phone extractions. One is the PDF, which is what I think you're referring to as the timeline of this communication, so on and so forth. And then there is the actual ginormous file that is read with a UFED program, and all that should be provided to you. Hopefully your laptop can use it. It does take some specifications on the computer to open it. In fact, we're addressing those issues at our office with our own computers. And if it doesn't work, we will cross those bridges as we get there. And I've worked with Mr. Lane before, just let him know. Mr. Lane knows how to find me. We will work this all out and get what you need.
Absolutely, yes. I am grateful for your information. Just to clarify, please, during the physical evidence and me viewing that here in the courtroom, am I not able to physically open my phone and search through it?
No, because
Okay.
it needs to be in a Faraday box where radio signals don't come and go, because anytime you turn on your phone, it changes the contents of the phone.
Thank you
You're
very
welcome.
much.
Ma'am, do you have any other questions?
One moment, please. Okay, so everyone is aware that I'm in the process of trying to talk to the captain. And handcuffs, okay. Your Honor,
Yes, ma'am.
I believe I am okay for right now. You and I do not have a direct way of communication, and I didn't know. Another big hurdle is if the laptop has internet access, where I don't know if emailing or messaging or whatever, however it is that you and I can communicate. Rather than snail mail, I'm writing a letter. I don't know when I write a letter how soon you receive it, because sometimes it's days or weeks that it is uploaded to the clerk's website. Do you have a general time frame of when you actually know of something? Because you already had my address correction, but I don't believe I've updated.
Well, it's been updated now.
No, I mean on the clerk's website.
I can't speak to what's on the clerk's website. I know for the purposes of my records and getting information to you, that clerical error has been remedied.
Do you have any other suggestions? If I do not have internet, would my only possibility to correspond with you be via mail?
That's my understanding. And you asked when I receive things. I get it as soon as I get it from in the mailbox. So we check the mailbox every day. As soon as I get it, it doesn't go to the clerk, it goes directly to me. And I review it. As you saw with the motions that you made reference to at our last hearing, that you had 5 of them, we set those for hearing immediately. And I intend on continuing to try to do that to facilitate prompt resolution to any concerns or issues or motions that you may have.
Thank you. And if I do have internet access or I'm able to put on, if it's not already, am I able to correspond with you via email?
You cannot correspond with me directly, but you can have conversations with my judicial assistant to the extent that you do have access to internet. I'll make sure to include her email address and telephone number in the order setting the deadlines that we addressed this morning.
Yes, thank you. And for any, I'm not sure specifically which JA, but as soon as something is scheduled, could you all please make sure that I'm included in the certificate of service or the portal or whatever it is I might be attached to in order to receive notices to be populated here?
Notices have been set, ma'am. To the extent that there was a clerical issue, that's been remedied, but you have been copied on everything that's been filed with the court, including the JAC's response, the notice of the hearing that was set for today, and the notice of the filing of the protocol. With that, I will see you all this coming Friday at 8:45 to address the motion regarding reasonable freedom in movement. State, anything else?
No, Your Honor.
All right, we'll see you all Friday. Thank you very much.
Thank you very much.
We'll return Ms. Boone to the custody of the Orange County Jail.
I'm grateful. Thank you.
Yes, ma'am. Thank you.
Okay, so they got a hearing this Friday, 8:45 a.m. to see if she's allowed to take cuffs off during these hearings. So to answer your question, Crystal, she'd have to have her handcuffs off. Otherwise, it'd be very prejudicial of them for her to ask questions while she's got cuffs on. So I imagine she would be out of that. Murph's Turf asks a question. What does Murph's Turf ask? What's she saying? It's always trouble when Murph's around. Is this snail mail or internal mail service? I think it's the jail is down the road, so I don't think it's internal. I think she has to post it out as anyone else would post it out. But obviously, because it's her, they take forever. Who's bring her up? Probably, I imagine her brother. I think she's got a brother, so I imagine her brother. Or that would be another faff because she'd be like, "Well, I need this, I need that." Now, there's a part of me. There's two parts of me. There's lots of parts of me. Oh, before I do that, sorry. Shout out, thank you to Maura, medallion. Thank you. She asked for send me a few curses today, Dylan. I need a laugh. Maura, thank you for the PayPal medallion. Thank you so much. Sorry it's so late me saying thank you, and also thank you to Carol Draper, the Disney Queen, for the PayPal as well. Thank you, Carol, darling. Thanks for your support as always. So thank you to Maura and Carol for the PayPals. Thank you very much. Very generous of you. So do we think, right, that she's desperate to see everything? Her phone, everything. She's desperate to see everything. So I'm just thinking, once she sees it all, she'll be like, oh, fuck. And she just wants to see it and then just to try and take a plea. Do you think, or is she narcissistical enough to be like, I'm going down anyway, so fuck it, let's go down. Let's go down and be famous. I'm leaning between both because if she can get a plea deal, because she's done for. I mean, she's going to prison for however long. So why am I doing this with my hands? I'm not sure. So she's grasping at straws. Maybe that's why I'm doing it. I'm not sure. She's grasping. So I know she wants to see. She's desperate to see everything. Right, go through it. Look, you're done for. The video's done. You done. Just get a plea. Try and get a plea deal. So wherever Murder 2 is, I think, isn't that, say it's 25 years, get 20 years for it. You've already done 4, or you're coming up to 5. You got 15 years left then, which means 20 years at 85 would be 17 years. You've already done 5, so you'd have 12 years left. When you look at that, after good behavior and everything, she'll have 12 years left, or even she might have less than that. Do you know what I mean? She needs to think. Like we say to men, think with the right head. She needs to think with the right head. So I don't know. Giovanna, my shirt is just saying she pulls away and the taillight is well intact. And it's like a picture of Jennifer Coffindaffer and the taillight, ex-FBI. And it's got Free Karen Reid at the bottom. I was just thinking, so I do understand what everyone's saying about she's a narcissist and everything. I'm just thinking, when you're looking at maybe 30 years in prison against maybe 15 years, in prison. Say it was 15 years. She's already done nearly 5. Do you know what I mean? If it's 15, she'd have 3, 6, 9, 30, about 13 years. So she'd have about 8 years left in prison. That's doable. She's got to think of her son as well. So if she's thinking of her son, she might take a plea. Now, the state might go, fuck off. We ain't taking any plea deal. She's going to trial. Do you know what I mean? That could be a thing as well. which I'd understand. Do you know what I mean? I'm trying to look for Alexi Traviso. Her hearing is today, but we don't know what time it's on that. Everyone said 9 o'clock. 9 o'clock New Mexico, which is now. But anyway, Boone, Boone, you're done. They got no choice, Daffodil. They got no choice. Someone from Bristol ringing me. They ring me every day. Yeah, it's a pregnant girl. Thank you, Terzia. Right, let's play one of the videos for people that don't know too much about this case whilst we still wait. Let's go, girl. Ba-da-bum-bum, ba-da-bum. Hey, big spender, boom, 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 spend a little time. Right, I'm gonna play this. I've never watched this before, so let's have a look at it. In preparation, hopefully we get to see Potty Mouth. You're supposed to sort me out with this hearing. And whilst we're waiting for this, whilst I upload this, come on, people. There's more people here than there has liked the stream, so press the like, press the like, press the like, please. Press the like and subscribe. It would mean the world to me if you liked and subscribe. Like and subscribe, everyone. Let's fucking go. So here we go. This is just a law and crime synopsis of this trial.
Thanks for tuning in to Law and Crime. Michael Bryant here. It was about almost 4 years ago. We had a case you may recall, Skylar Richardson. This is the young lady who goes to the prom, comes home, and it's very exciting, the prom. So she's using the restroom in her parents' home and has the baby in the toilet there. She then proceeds to take the child and bury the child, Annabelle, in the yard. And she was charged with murder. She was charged with mutilating a corpse. She was acquitted on the murder charge. They found that the child was stillborn, therefore you couldn't have a murder, but she did get 3 years probation, and I believe that probation period is now up, and she's out. Interestingly, she now works for the law firm that represented her in that case and wants to get into the law. I say all of that because you would hope that that's kind of a rare case, but no. There's a new case that we're turning our attention to now. This is developing out of New Mexico. Pretrial motions yesterday in a hearing for Alexi Traviso. She's a 19-year-old accused of killing her newborn baby by disposing of him in a hospital trash bin. The defense is claiming, not surprisingly, that her son was stillborn at the time. This is January 27th. And the state is saying, no, this is murder. Trevizo facing first-degree murder charges, child abuse, tampering with evidence, etc. So before I bring in my legal panel to talk about this new case, let's look at the defense attorney, Gary Mitchell. He's outlining the important timeline for us from yesterday's hearing.
This entire case hinges around what happens in a bathroom in the emergency room of Artesia General Hospital on the date in question, which was January 27th of 2023. The timeline will tell you that there's one admission sheet that says 12:03, but by 12:05, she's in the emergency room. And then within a few minutes, she receives medication and through an IV, and including morphine and several other different kinds of medication. It's a timeline would reflect. Without getting into that too much, she She's examined by an emergency room doctor. She has a nurse that's there. People come in. The hospital asks for a UA, and blood. They do a blood test. And by 12:51, they know that she's pregnant. And then we know, when it comes to this privilege, that according to and they happen to have a video camera or some type of camera in the emergency room part of Artesia General Hospital that shows her leaving her room. And we know from the records that at 1:39, she leaves they go in, they unhook her from the IV, let her get up. She virtually runs down the hall, trots down the hall to the bathroom. And then, according to the police report that you have from Officer Minter of the Artesia Police Department, who reviews that video and goes through it, she's in the bathroom for approximately 18 minutes and then leaves the bathroom and goes back to her room, and then by a certain time period, and let me pull that up so I can speak intelligently to the court. We know that after the 18 minutes in the bathroom, we know she's back in the room, and we know that emergency room personnel go in and they begin, the cleaning staff goes in and they begin to clean the bathroom. And later and that begins at 2:08, and then by 2:27 they find the baby, and at 2:38 the doctor pronounces death, and then police arrive after that.
So very important timeline, a little different than the Skylar Richardson case. No surveillance video of what was going on that night in Ohio, but we have that here in this case. Rich Schoenstein's here, Krista Ramey here. So Krista, there was a lot of extraneous stuff in the timeline there, but it sounds like the defense is going to be, hey, she was given all these meds, and that effectively caused the birth, whether the child was alive or dead before that. It's the hospital's fault. What's your take?
Well, it's the state's burden of proof to prove that that baby was in fact born alive and that she killed her. So, right there, the timeline of the evidence with the medication that's given, morphine included, to her when she arrives at the hospital doesn't really help the state's case. And the fact that she was in the bathroom for that period of time without any, we'll hear, what the evidence is, but is there evidence that they heard, a baby crying in the bathroom? Then maybe, we've got some good evidence of a live birth. But you have to have evidence of a live birth in order for there to be a murder. So I think that it's going to be a little bit of an uphill battle with that timeline.
Yeah, I understand. Obviously, we're way premature in this thing, but I understand there's been some medical records suggesting that the child had oxygen in its lungs, or at least had evidence of having taken a breath. That's pretty clear sample of maybe life and not stillbirth. Anyway, the defense here, Rich, is arguing an interesting privilege question, I think, with the video footage from the hallway. And we're going to see that in just a moment here. I don't know that would be protected under the client-patient privilege. What do you think?
Yeah, I don't know if it's just video footage of somebody in a hospital. That's not an interaction with your medical provider. I think of the patient privilege as being, your communications with your doctor, not what you do in the hospital on the way to see a doctor or in between seeing a doctor. So depending on exactly what the video is of, I'm not sure the privilege would apply either.
Yeah, so we'll see how that shakes out as this thing gets closer to formal trial, if that's going to happen. We do have some body cam footage too from the night in question. Let's watch some of that.
The pregnancy test on her showed positive. She was denying that she had sex. Then she said she had to go to the bathroom. She went to the bathroom. She was in there for quite a while. We kept knocking on the door. Finally, we got her to open the door, and there was blood everywhere. She was cleaning it up. Okay. So we took her back to the room, and I was afraid that she knew she was pregnant. She had done something to herself. Mm-hmm. So the doctor started doing a vaginal exam on her. We had the lady come to clean the bathroom. She put the baby in the trash can, and then she put another clean liner over the top of it. Oh, wow. Okay. So when they looked in there, there was no trash in there, but it was underneath the clean bag. The baby's dead. Okay, we have him in trauma too, but she killed the kid.
We discovered a dead baby in the bathroom. Oh my gosh. I'm sorry. He came out and he didn't know what to do. Lexi, I told you about this. I just asked you, baby, to tell me the truth. It was not crying or nothing. What did you do to it? Okay, stop right here. Stop.
Do you guys have, I'm the charge nurse here. Do you guys have any questions for me?
Like, how big is the baby?
It's full term.
What? 9 months? Nothing was crying.
Well, right now, she's being detained. So she's not going to leave from here at all, period. Okay? So one of us will
Is
be
it in your custody? Like,
yeah, she's detained. Yeah, she's not under arrest, but she is detained. Okay, she's not free to leave.
Wow. I mean, that's some crazy body cam footage there. And you see the mother, the young girl, she's tiny, and she was full term, 9 months. Rich Schoenstein, Krista Ramey. Krista, I don't know how you hide that, first of all. And she was a cheerleader, too, which is also kind of something that Skylar Richardson was. But how do you hide that kind of pregnancy? And then, follow-up question, how do you hide giving birth? I don't care if the child cries or not. How does she not cry, the mother?
Well, remember, you're not developing a healthy pregnancy here if you're hiding it. So you're not going through the normal weight gain that you would go through because you're eating for two. You're taking vitamins. You're intentionally getting the nutrients that's required to carry a baby to term. You're trying to hide it. So, assuming that, some weight gain is normal in children at various ages, particularly in their teens, and I would assume that, it can be hidden, baggy clothes, whatever, I don't know, but I don't know that, how you hide that from your family for that long. And, it can happen. Apparently it does, though. This is not the first case we're hearing of. It's not even the second case. It's a frequent occurrence, unfortunately. So,
with this case and with Skylar Richardson, they were both very tiny people, and they hid it. Yeah. It's amazing to me, Rich, and I haven't given birth yet. I'm not counting out the possibility, it could happen. But I would imagine that it's, to do that quietly for 18 minutes in a bathroom, I don't know how you control that. It just doesn't make sense to me.
Well, listen, I've never given birth either, but I have attended 2 of them.
Yes.
And they were very loud events in all respects. The mother was loud, the new baby was loud. So it is hard to imagine that happening and nobody hearing anything, if it's happening in the bathroom. I mean, the whole thing seems tragic. I wish we lived in a country where we prioritized healthcare and women's rights and reproductive decision-making. But since we apparently don't, I think we might see more and more of this kind of thing.
Okay, and that is Rich Schoenstein officially on his soapbox. So he's going to step off of that. We're going to take a quick break, and we'll come back.
Wow. I need to go more. I'm intrigued now. Let's deep dive, shall we? Not deep dive too much, but I mean, let's get into it. All right, what's this? Right. Let's get it on. Right. Let's go.
I want to knock on front. Alexi. Yeah, I think they want to.
I'll bring her out. Just tell me what's going on. Okay.
I will give it to her whenever.
Can I see her?
I'm gonna put some subtitles on because it's so windy. I can't hear it. But you won't. Right, let's go here from here. Go back.
Yeah, I think they went out.
I'll bring her out. Just tell me what's going on.
I will give it to her whenever
Can I see
she can see the warrant when she gets arrested.
This is my house. I have a right to see the warrant.
I'm letting you know she has a warrant for her arrest. We don't have a search warrant for your house. We have a warrant for her arrest.
Okay, can we see the warrant?
Yeah, once we she gets a copy of it.
Can I go up there when you take her up there?
You can go to the detention. Do you know where it is?
Everything?
It's
Okay,
lower.
so what is she under arrest for?
She's over 18. Just gotta talk.
I understand that,
Right.
Detective Gonzalez. What is she under arrest for?
Oh, her mother is going to be a pain in the ass. Her mother's going to be a right pain in the ass and all this. Oof. Right, I will say, right, Josie. So those that don't know, Josie and Murph, they literally pinned me against the wall to stream this. So yes, you were correct to do it. This is quite interesting. So thank you for being shouting at me, and you and Murph kicking me and punching me. Thank you for the abuse, both of you. Thank you for that. I think we could be glad to cover this, even though it's going to be a sad thing. I think, but yeah, all joking aside, I'm glad we're doing this. I want to know more though, so we'll watch a few videos. I loves it. I love it when Murph's here giving shit to everybody. I loves it. Right, let's go.
For what?
That's all I'm gonna Okay.
What do you mean that's all you're going to tell me?
She's over there.
I understand that, but I have a right to know as well.
We'll tell you that.
Okay, then let me know now. Let me know now. I'm giving you the corporation. I told you answer my question. What is she under arrest for?
She's over the age of 18. Like that's not that we can't really put that information. But bring her out here.
What is she under arrest
Bring her out here.
for?
We'll tell you right
No, I'm not bringing her out here yet. Let me know what she's under arrest
She's
for.
gonna get arrested regardless. I don't know why.
For what? For what? For what?
You okay with telling me?
Tell me.
Homicide. Open count of homicide. And tampering with evidence.
Tampering with evidence?
Yes.
At the hospital?
So can we see her now?
Give me a minute.
Okay.
I have a right to see a warrant. It doesn't matter if she's over the age of 18. This is my house. You have a right. You have to show me that warrant. Even if she's under arrest, you have to show me the warrant.
Up to her to show us.
Sarah, this is Rodriguez. Hey, I have the detectives here. They want to arrest my daughter. They're saying they have a warrant, but they can't show me a warrant for her arrest. Okay, thank you so much.
You good?
Like, I get it. Right. So to give her some grace, she's a mother. She's trying to protect the daughter and everything. Now, obviously, this is the first time I'm seeing this, so you know you're going to be protective and stuff. But like, she's over 18. She's over 18, so you can have no rights. I know you want to know why she's been arrested, but like, just go get her. She's in bed. She's like, the cops could be going into your house, going, "We want her out now. We're coming in to get her. Get her out of a fucking bed. She's arrested." Do you know what I mean? They don't have to be that nice. Just go and fucking get her. So I get it, but like, take her with you. Get her, bring her out, speak in front of them, and everything. So I do get the mother. I do get it. Hang on. Somebody said something here. My pup is called Murph. There you go, Murph. And he keeps looking at who's saying anything. Hello, Murph. Hello, Murph. Murphy, hello, Murphy. This is how I actually speak to Murphy herself. Murph's turf, hello, Murph. I love you, Murph. I'm Mama Little. Hello, Murph. Yes, Murph. Ah, who's a good little Murph? Murphy. I love it. Right, okay, let's get back to it. He's wagging his tail. That's what Murphy did. That's what Murph's turf does. Murph, who's a good girl? Murph, who's a good? Normally Murphy's slicking my face, but now who's a good girl, Murph? Murphy. I just say we get some walkies, Murph, walkies. I love it. All right, let's go back.
So when we get to there, I'll give you a copy. She gets her copy. And it's up to her.
Can I see the warrant?
It's an arrest warrant for her. It's
Okay,
not a
can I
search
see the
warrant for your
arrest
house.
warrant? I want to see the arrest warrant.
And what will that prove?
You bet when this is over, I'm coming for the police department and the hospital. I am.
Yes, ma'am.
Gary, this is Rosa. Gary. The detectives out here wanting to arrest me. They say they hasn't shown me. He hasn't shown you. Or anytime. No, search.
Hello, Betty. Betty.
Okay. So I guess do I do it? Okay.
You can arrest mom for obstructing.
We'll go there.
Trying to
Get a
do that.
protective thing.
I like what he said there. Did you hear that? I liked what he said there. The guy who's got the camera on said, "Well, we could just arrest her," and the other guy, detective's like, "No. She's just been a protective parent." Well, I like that. That he said that she's just been a protective parent. Spot on. As annoying as she is, she's just been protective. So fair play to that detective. Hats off to him. That was really, really good awareness by him. Betty, where are you, Betty? Betty, go and play with Murphy. Murphy, go play with Betty.
They said it's local statement, homicide, and tampering with evidence. Okay. Okay.
Probably just nosy neighbor.
Okay. Okay. Yeah, she's here. She's here right now. Yeah.
Oh, no. Might not be a nosy neighbor. Guess I could have a better part of
Could you please let me know?
that is his policy.
I will give it to you. Please don't. Please don't.
She ran away from 1002 West Washington. It's nothing personal. It really isn't. And we understand. But we have to do our jobs too.
I understand that. I understand that. That's Melanie. That's Devin's mom. She's good. She's okay.
We're not gonna be rough with her or anything. We're just gonna take her over there and book her.
Please don't be rough with her, please.
Just bring her out. You can be with her the entire time, okay?
Do you know where the public safety complex is? 3200 West Main?
You can follow us over there. I will take you there. You can follow me over there.
As soon as I release the criminal complaint to her, she can then give it to you there, okay?
When can I get like her bond? What?
That's set up by the judge. It's Magistrate Judge Chuck Foster. He should be doing it if it's after 3. He'll be doing it in the morning. Go on the back. All right.
Hi. What's your name?
Alexi.
Okay. What's the last 4 of your social?
She don't even know it.
You don't know it?
I don't know. I don't remember.
Alexi, do you know your date of birth?
Yes.
Okay.
What is it?
11/25/03.
Yeah.
Do you have to walk her all the way up there? Can you bring your car up there? Please.
Yeah.
That's all.
I'll go get it.
Alexi, are you okay with your mom getting your criminal complaint when we get to the detention center? It has your personal information
Can you
on it.
repeat that?
Are you okay with your mother getting the criminal complaint? It has your personal identifying information on it. Serial number, date of birth.
Yes.
Are you okay?
Yes.
Okay. I have to serve you first, then your mom can get it, okay?
Okay.
I do. He's gonna move his unit around. No medications, anything you need to take while you're in there?
No, sir, no.
Okay.
She has still been like bleeding, so I don't know if she needs.
Do you
like,
have any? They do. I don't know if they have tampons.
They do have feminine products.
Okay.
Okay.
But I'm pretty sure if you take your own, you can use your own.
Can she? Do you want to grab some? Can she grab some of that real quick? Or?
Yes.
Do you mind if
Get your little bag.
one of us goes?
Go ahead. Go ahead. Go ahead.
Just making sure you're doing.
Just grab me a little.
Okay. And just nothing sharp, no flammables, nothing sharp. Okay. Okay. They're gonna check it when you get over there. Okay.
Okay.
Confirm that address is 611 North 1st Street. 611 North 1st.
Okay. We'll check those. Same thing. Okay. They're gonna check all that when you get over there. Okay. Thank you.
I'm going up there right now too. Okay.
All right. What's in there?
Personal pads.
Personal pads?
Yeah, she needs them.
Follow me.
3200 West Main Street, Public Safety Complex. If you just go through the front door, you know where we first spoke in the records?
Yeah.
If you just go over there. Is there already 4?
Yeah.
Okay.
I'll meet her in the front.
Okay. I'll get with him and do all stuff. Go to dispatch.
I'll meet you in the front. Okay.
We're Tampa. I'll be headed your way.
Relay the rest.
I'll be headed your way for the relay shortly. Okay. Alexi, here's your criminal complaints. What I want to ask you before I give it to your mom, are you okay with her getting that information? Serial number, all that? Okay. Would you want to keep this to read or would you want to give this to your mom or would you want her to have a copy?
You can just give it to her.
Okay, you don't want to read it?
Right now, yeah, I will.
Okay. All right, the next one is a search warrant for your person. Okay? This is for you. Your date of birth, your social security number. I'm going to be searching your person. What I'm going to be doing is getting a buccal swab sufficient for laboratory testing. Okay? This is both yours to keep. Okay? I'll make a copy so you can read it and your mom can get one, okay? Have you ever been to the doctor's office?
Like recently?
No, just in your life.
Yes.
Okay, you know when they do a swab of your mouth to see if you have a cold, something like that?
Yeah.
That's all I'm going to be doing. All I need you to do is open your mouth wide, like you're yawning. I'm just going to touch the inside of your mouth with a swab, with a cotton swab. That's all I need, okay? It's painless. There's nothing else added to it. It's just cotton, okay? Here. All right, can you open your mouth for me? Okay. All right. Almost done. All right. Now I'm just going to do one more pair, okay? Okay, one more time, okay? Go on, do the other side of your mouth. All right, that's it. You don't want to read them? Well, of course, I'd like one.
Right here. 3, 2, 1. Face your whole body this way, looking forward. You parking the front or the back?
The back.
Now face the other direction.
Pull your hair back a little bit, please.
You guys want to sign? Who wants to sign? I need to sign.
One right there, one right there.
One.
Right there, and one right there.
I sign?
Yes.
Okay. Because I did witness it.
And then I'll give you a copy for yours.
This one?
Mm-hmm.
That says signature on our top or other witness.
If you finish.
Let me finish reading that, sir. I'm sorry. There you go.
That's it. And I'll get you a copy for you.
What you got so far? That one. Two, that one.
I'm hard to find, sir.
Is that mine? I think yours.
I believe it's mine, sir. And we did it approximately 4:30 p.m.
Hmm?
Yeah, that is mine. Don't take my pen. And this is just showing you, this goes with this one. It's showing you, I got 2 pairs of buccal swabs sufficient for lab testing, okay? There's the 2 we got from you, okay? We can make you a copy.
It's fine. You can just give it to my mom.
So both, all of it?
Sure. Yeah.
Okay. If you want a copy, you can get it from him, or if I'm here, you can get it from me, okay?
Wow. Wow, wow, wow. This is huge. This is huge, people. Right, I need to know what the timeline for this was. Because I just seen, right, correct me if I'm wrong here, Potty Mouth, you seem to know what you're talking about for once in your life. So she gave birth, she's let go, she wasn't arrested, she went to prom with a boyfriend, and then afterwards she got arrested. That's what I'm seeing, but I need to look more in depth about some of these things. Wow. Right, there's some more stuff here then. Wow. Let me find this. Where's this video gone? Right, hang on. So this is the night there was. Oops. Okay, so she's airlifted to another hospital, released from hospital, arrested after investigation, released in Korea. Okay, fine. She's been out for, okay. So she was arrested and then she went to prom afterwards because the prom was like 3 weeks afterwards. I think they phoned him straight away. I think they phoned him straight away. See you in a bit, Carol. See you in a bit. Her trail's been delayed again due to a defense filing requesting the hospital body cam. So, Murph, there's supposed to be a hearing today. The pre-trial hearing is today. Today is the day for pre-trial hearing, but I don't know what time. So hopefully that covers a lot of it. Anyway, let's look at this then in between. Because Pottyman's supposed to find out for me when it's been done today, but cops were at the hospital that night, yes. Yeah, so it was postponed. What, again? Because it was supposed to be the 25th of July or something. So if I look here, Murph, every time I hear Murph now, the dogs are wagging. So the pre-trial hearing was changed from July 22nd, 2024 to August 6th, 2024. New Mexico court case records for Alexi Traviso show that the pre-trial was moved to August 6th, which is today. So unless you're saying it's been cancelled, postponed again. Oh, okay. Okay, maybe Murph's right then. Okay, no, but maybe Murph's right then. Not until decisions made about the body cam footage is critical to the case. Oh, fuck. Okay. Let's do this again then. Let's listen to some of these testimony then. Oops. Oh, they're muted as per usual.
Yes. Okay, I'm Detective Officer Chief Police Department. What questions do you have for me right now?
What's gonna go on? Like, what can I be with her?
She's getting life flighted out right now.
Okay.
So they're taking her right now.
Okay.
I haven't spoke to her at all.
Okay. So what's gonna go on? Like, what's gonna happen with her? Like.
So she's gonna get treatment before we even talk to her because she needs to be stabilized. So
Mhm.
that's why she's getting life flighted out.
Okay.
Once she gets stabilized, we'll try and talk to her. The baby's gonna go up north for autopsy.
Mhm.
More likely, it'll be done within the next day.
Is she gonna get detained after like she's released? How?
Get what?
Like, are y'all gonna take her into custody or anything like that? Like,
That depends
what?
on what the DA finds. We have to wait for the autopsy to come back to see what happened. Because right now, with how everything happened, we're going to do an investigation, get more information from the OMI, Office of Medical Investigator up north.
Mm-hmm.
And with that, we present that to DA, see what the DA wants to do with charges, if any at all.
Okay. Okay. So they already took her out.
No, she's getting life flight. She's right now being set up to go.
Okay.
What happens?
What do you mean?
Before the DA makes a decision on that.
It should be pretty soon. They make a decision. Because with the age of the decedent, they usually expedite autopsy reports and such. With normal people that pass naturally at home, takes a couple months for us to get reports back. Stuff like this, we'll get it back pretty soon.
Okay.
So
Still, they don't know.
we don't know. That's why he'll be going up north. Has y'all's information been taken yet?
He took my driver's license. He took her driver's license.
Okay.
My phone number. My phone number. Yeah.
So, even though she's of age, if she's not available to be contacted, can we put you down as next of kin for all my? Okay. And you'd be grandmother?
I'm mom.
So you'd be
I'm
the
her mom.
you'd be the decedent's grandmother.
Yes.
Okay. Just wanted to make sure.
So that's her boyfriend.
Mr. Boyfriend, do you have a driver's license? No.
Oh, right, okay. So this is the boyfriend. Okay. This is Alexi. Oh shit. Alexi's mother, Alexi's father, and that's the boyfriend's mother. Okay. Okay. Now we're getting somewhere. So she's a grandmother, and she's a grandmother, and this is the boyfriend. Fuck. Devon Ferrier. Okay. Oh, stepdad. Okay, so Murphy's just correcting me. This is a stepdad, this guy, not the father, Alexi, stepdad. Good question, Dottie. Did the boyfriend know? Did he know? Yeah, we're just learning. I have no idea. Baby daddy didn't know. Murph, you're such a star sometimes. You can be a bitch sometimes, but you're also a star. Thank you, Murph. Look at this. You know I'm joking. Here we go.
And is the address on you current on the driver license? Because determining on what the OMI does, if she's still in medical, and they do release the infant back, it'll have to be released somebody. It'll be up to OMI who they determine next of kin is. Maybe the parents, but maybe you. Okay, so that's why we're gonna get everyone's information. I'm just gonna run your name through the special on radio. Okay, so I'm just gonna call them. Hey, Gibson's off 7:15. Are you on APD? For the AG's call, can you run 1 OLN out of New Mexico? It's 517-158-500. Should be Devin Fierro. Yes. No, it's okay. No, is it Rick? Okay, so I'm coming across that, so like 45 minutes. All right. Thank you, sir. Appreciate it. Oh, you as well. Thank you.
As soon as they're done with her, like if everything's okay, will I be able to bring her home with me?
Yes.
I will?
Yes.
Okay.
I don't know where she'll be going.
With me?
No.
To my house? I mean, like.
When she gets life flighted.
okay.
I don't know which one.
They told me Loveless Regional. Yeah.
Loveless Regional?
Yeah.
That's my card. Get a hold, keep a hold of me.
Okay.
So if she stays at Loveless and then she gets released, she can go back to y'all.
Okay.
And I'll be in touch with you to try and set up an interview with her.
Okay.
Would y'all mind talking to me later when y'all are okay?
Yeah, I was with her. I know she talked to him for a while on the phone, and then she came to me, so I've been with her the rest of the time.
Today? Oh, so what did she come here for that she told you?
She told me she had back pain.
That's it?
That's it.
Okay. Has she been having back pain before?
Yeah, pain for her and her hips is no, I mean, she was born with like her, I don't know, it's like crooked.
Her spine?
Okay, because my ex-husband, he hit me. He beat me whenever I was pregnant with her. So she was early. So she had some problems with her hips. Like I always had to take her to chiropractor to get adjusted because she couldn't use, like, she was always getting constipated. Like she had to get lined up, whatever. So, I mean, I've been taking her to chiropractor because I always thought, well, this time, I didn't know. I honestly didn't know she was pregnant. I didn't know. I just thought, like she said, I have back pain more. My hips are hurting me. I think I need to go to the chiropractor. I said, okay, let's go tomorrow. But she was like in really a lot of pain and,
When did it start?
Like the pain?
Yes.
Yesterday she said it was really bad, that her hips were hurting and her back. And then last night we're on the phone together and she said her hips were hurting bad. I asked her if anything else was hurting, and she said just everything. And she went to sleep.
But she's a cheerleader too, so she's big in cheers. They have cheer competition. She works out. I mean.
And she's been active this whole
yeah,
time?
Yeah, she's been active this whole time.
And who does she live with?
With me.
So
parents are with us. Yeah, because she's in school. She's a senior.
And how long have you all been together?
Almost 2 years.
2 years? Okay. So I'm not trying to be rude to you, but you are more than likely would be the father? Okay. Yes.
No, we get it. We get
Sometimes it happens. So with everything that comes with that, gets a little shaky when it's newborn, stuff like that. But with like death certificates, stuff like that, interpreting his sons, if you choose to use them, we'll be the ones to help you get those. Other than that, because that's all really you'd need, and they can help you with the afterlife care. Okay.
Mm-hmm.
Do y'all have any questions for me right now? Okay. You have my number. You can. That is my work phone. If you want to text me or call me, I have my email on there as well. Okay. Sergeant and I got your information right.
Yes.
Okay. Let me give you my card too, so you can give me a call. All right. Just because I want to make sure everyone stays updated. Okay. Like I said, I don't know. There will be charges that will be up to the district attorney's office, if any are even done. Okay.
Okay.
It's too early in the game to know right now.
Okay.
So we're just gonna do the initial investigation. I was on the phone with our dispatch, so all mine will be here in 45 minutes. It's one of their field agents,
okay.
And they're the ones. So in the state of Mexico, we're not allowed to touch anybody that's passed.
Okay.
They're called a decedent. They're the only ones allowed to actually handle somebody. So we wait for them to even do anything. So hospitals allowed to do it because they do care, life-saving efforts. Whenever life-saving efforts cease, no one's allowed to touch them. So we have to wait for them to show up before we even start that side of stuff. Okay.
Okay.
So she's getting life flighted out. We'll talk to her later.
Okay.
That's if she even wants to talk to us, if she chooses to, because she still has her constitutional rights.
Should I get a lawyer for her? Should I?
You can. That's your choice. I can't tell you what to do. That's something that y'all as a family talk about, okay?
Well, why we would talk to her over the Roswell?
Yes.
But I go right here, they won't let her.
Yeah, they wouldn't let us.
She should be gone by now.
Okay.
So that's with the helicopters coming in, they want nobody near it, so that way you can't
Yeah.
mess with anything. Because if any of their vitals go off, they'll stop it,
Yeah.
which could be an issue for if they need care immediately. So that's why whenever someone gets life flighted, they cut off every contact with the family
Okay.
because they're making sure she's getting set up to get transported out.
Okay.
So that's why they tell you leave.
Yeah.
It seems
Okay.
very harsh, but it's because with the flight nurse, the flight doctor, they have to make sure everything stays constant.
Okay.
So she should be gone by now because she was already getting prepped whenever I came out to y'all.
Okay.
So with that, like I said, she'll be leaving. We'll stay here with Destinat and go from there, okay?
Okay.
So once she gets to Loveless, it's up to Loveless if they'll let you back there.
Okay.
Because she is of age, so
Mhm.
with COVID and how everything goes, it just depends, okay?
Okay.
So if before you make this drive, I'll call, see if that's available,
Okay.
and just let them know what's going on, and we'll just let your family and that it's possible.
Okay.
All right?
Okay.
We'll be here if you need anything. Yeah, well, I'll be over there, and I'll
Okay.
just be waiting, all right?
Okay. Thank you so much.
All right, folks.
Sorry, I was just doing a couple of downloads. Right, I did not know. I've just found this out. Just found something out. I found a couple of things out actually. I need to go put my VPN on. I can't. I don't know where my VPN is. Hang on. Let me get this up. So I just found out something. I'm not sure if everyone else knows this. Share screen. So state of New Mexico against Alexi Traviso. So she took a polygraph. So no, is there a date here somewhere? No. So she took a polygraph. Defendant Alexi Traviso by and through her attorneys Gary C. Mitchell, PCM, pursuant to the Mexico rules, gives notice that he intends to use polygraph evidence at trial and hereby certifies he served via email upon State of New Mexico link to the following: a copy of the polygraph examiner's report, a copy of each chart, a copy of the audio or video recording of the pre-test interview, actual testing and post-test interview taken by examinee in this matter in the question. So there you go. I did not know that. I did not know that then. That's interesting. That's interesting. So she's got polygraph. We'll see what happens. Also, everyone, I know there's some questions here. We literally just, we know nothing about this case. We know there's a couple of people who know something about the case. I know literally zero. Whatever I've played today is the first time I'm hearing all this stuff myself as well. So you're coming at the right time. We're learning together. Right, hang on. What's Murph? August 30th. What's August 30th? Is that the pre-trial Murph, yeah? I'll take it that it is. Hang on, I've ignored chat, that's why. Oh, the note this 2023. I didn't see that. 2024 now, aren't we? They're supposed to be, yeah, they're supposed to be, well, I mean, we don't know. Anyway, right, there's another one I got from Josie here. Let's take a gander at this one. Let's see if you can get this one. She must have passed it, Joe. She must have done really well in it because it's them that did it. So I imagine that she wants it in. Share screen. So this was her before, as in before she gave birth. So she's obviously £100 before giving birth, as in normally. So that was her. I'm not sure how long before she got pregnant, as in before she gave birth. That was. So we'll see. That's, you know, she's got a bump. Do you know what I mean? She's got a bump there. So I don't know. Whoa, there's a lot we're hearing about here, isn't it? I would say, I mean, yeah. If I got another picture, I can maybe get that of her normally. Hang on. Let's get into it. Hang on. Let me look here. Google Images. Let's do the time up again. You can see how unprepared I am because I didn't think we were doing this today. As in, I didn't think we would do it this. Okay. Bear with me. Oh no, I'm not showing that. I don't need to show that. That's take the step to the left. Hey. Okay, I got right comparison here. 2 seconds. Let me get this. Let me get this. If I'm able to do this. Yes, I am. Right, I got that one. And I got another one to compare it to. If I could turn back time. If I could fly away. Download that bad boy as well then. No, I can't do that one. Right, I need to open it up. Hang on. I'll get this bad boy now. I'll get it. Save image as. I got it. Right. No, wrong way. Cancel that out. Right, here we go, everybody. Share screen. So this was her pre-pregnancy. Yeah. This was her, like, literally, I think, her usual. Let me move. Sorry, let me move myself. I'll put myself down the bottom there. There's me there. All right, there's her. That's her there, right? Then so you can see, super thin. This is her then. Like literally still as a cheerleader. Do you know what I mean? I mean, come on. Come on. I mean, that's just a different girl. I never talk about someone's weight, but I mean, that's a bump. I'm not even saying that's a bump. I wouldn't, I'm not saying that I would initially think she's pregnant there, but I would have said, like, she put a bit of weight on. She's put a bit of weight on. Do you know what I mean? How do you, we all got some cushion. I did, Heather. I showed it before. Hang on, is there another one then? That one, Heather. Yeah, I mean, I've seen other photos now. Hang on. Let me get this another one on. Oh, no worries, Seth. Seth, I don't know how you cope with Heather. I mean, I love her, but friggin' Nora, she's a handful, isn't she? Boss E. Right, and there's another one here. You deserve a medal, Seth. You probably got a few already. Right, share. Another one. That's her stretching. And you can see there's a bump. Oh, wrong one. I love it. I beat. Oh, Josie's got an even better one for me. I was just about to say, fuck, I beat Josie to it, but I didn't. She's got a better one. She's got a better one, people. Hang on. Josie always comes. She always delivers. She always delivers the goods. Ah, fuck. I was just about to speng as well. Be like, hey, Josie, I got it. You're too slow. She beat me to it. Bollocks. Right, I got a good one here, thanks to Josie. If I could turn back time. Here's Josie. Look how talented she is. So this is the before and after, people. Wow. Oh, hang on. Murph said something. They found phentermine in her system, and in the baby's autopsy, she was taking diet pills. Fuck. I know Seth deserves a massive amount of medals. All the medals in the world. What? Yeah, diet pills. Just got that. Jeepers. Wow. That what a difference, Oof. What a difference. Oh, Murph's got me another one. Hang on. Look at these. Look at these mods. smashing it today. Look at them. Another picture for us. Her and her boyfriend afterwards. Seth is Mr. Heather. Seth is the guy who deserves a shit ton of credit for keeping Heather happy. Right, so there's another one here. This is after she gave birth. If I could, I would. I love you. So that's them together. This is like 3 weeks afterwards, 23rd of 4th. So she's out on bail here. She hasn't got any thing on her. So that's a prom picture. Wow. Artesia High School prom picture. Jeepers, like you know, everyone's got to get on with their lives, but I'm not sure I would go to prom like weeks afterwards. You know, I wouldn't want to put my face in public, I don't think. Poof. So yeah, I think this was like 3 months. This is 3 months after the incident. So I thought it was 3 weeks. 3 months. Lucky we got people like Murphy here to correct me. Wow. Actually, saying that, Josie posted something for me, which should be quite good in the right now, maybe. I don't know to say I love you, and I want to say I care. Right. Visit site. Hang on. Right. I think this video will show us a bit more about the timeline, I believe. I think. I know we don't really like. Well, I mean, Vinny's okay, but. Oh, hang on, my bosses are messaging me again. What have I done now? Oh, no, that was something else. Okay. So this is the timeline. Whatever you think of Vinny, that's fine, but he'll give us some timelines. Right, hang on. Let me just do that. Present.
I'm Vinny Politan. Thank you for joining us here on Closing Arguments. And every time I talk about the story, I begin in the same place. Like, how does this even happen? How does a young woman go to the hospital for back pain who's actually pregnant and about to give birth, end up in the hospital, delivers the child herself in the bathroom, and the child dies? Like, how do all those things happen? Now, prosecutors have their theory on all of this, And their theory is that she hid the pregnancy. She knew she was pregnant. She had the baby. She killed the baby. Then she tried to hide the baby in the garbage, in the bathroom, in the hospital. That's their theory. The defense has a completely different theory. We're going to talk about it tonight. But for those of you who don't know the story of Alexi Traviso, take a listen.
She put the baby in the trash can, and then she put another clean liner over the top of it. Oh, wow. Okay. So when they looked in there, there was no trash in there, but it's underneath the clean bag. The baby's dead. Okay, we have him in trauma too, but she killed the kid.
We discovered that dead baby in the bathroom. Oh my gosh. I'm sorry. It came out and he didn't know. Lexi, I told you about this. I just asked you, baby, to tell me the truth. It was not crying or nothing.
It's cold and blue already? Cold and blue already. His temperature was like 95. No signs of life, no breathing, no respirations, no heartbeat, nothing, no movement whatsoever.
I mean, I've been taking her to chiropractor because I always thought, well, this time, I didn't know. I honestly didn't know she was pregnant. Should I, get a lawyer for her? Should I?
You can. That's your choice. I can't tell you what to do. That's something that y'all as a family have to talk about, okay?
At 51 minutes after midnight, they know she's pregnant because they ran the blood test and they came back. Now, they didn't tell her that she was pregnant. They didn't tell her for another 48 minutes. Well, they never told her. She learned she was pregnant when she went to the bathroom.
Okay, so she's been charged with killing her baby, her newborn. But now there's a civil lawsuit that's been filed. Not against her, against the hospital for wrongful death. And one of the attorneys filing that lawsuit is also the attorney representing Alexi Traviso. And he's joining us now from Ruidoso, New Mexico. Alexi Traviso's defense attorney, Gary Mitchell. Gary, great to see you tonight.
Good to see you.
All right, so there's a civil case now, okay? So a civil case accusing the hospital of wrongful death, a criminal case accusing Alexi of killing the newborn. I just want to start here and go through a specific timeline because I want to get a clear understanding of what happened here. So at 12:51, and I've heard you say this, that the results from the pregnancy test, after she goes to the hospital for back pain, she says she's not pregnant, right? But they do a blood test. You say the results are done at 12:51. What does that mean? Does that mean the results are showing up somewhere, or someone actually read those results and someone acknowledged reading that the results came in and they knew, oh, at 12:51 she was pregnant?
All three, actually. It's a computerized system. At 12:51, the lab sent the results via email or transmission via computer to the nurse's desk, to the emergency room physician, and to the nurse assisting Alexi. At 12:51, the nurse assisting Alexi knew she was pregnant, but thought that the doctor should be the one to tell her. And for 49 minutes, they didn't tell her. And in fact, they never told her until she went to the bathroom, thinking she had to go to the bathroom. But it turns out she was actually having a baby.
So this is huge. I just want to stop you right there for a second, because this is the part that I wasn't clear on. So as she's running down the hallway here at 1:39, right? That's 40. That's how many? I mean, that's almost an hour, right? An hour after they have these results and don't tell her that she's pregnant. But if they know she's pregnant,
that's right.
And she thinks she has to go to the bathroom, like, that's a sign that you're about to give birth, isn't it?
It is for anybody that's ever been around delivering babies. You don't have to be a nurse or a doctor to know that.
So when she's running out of the room, who's in the room at the moment? Is the nurse there? Do they know that she's left the room to go to the bathroom because she feels like she has to go to the bathroom?
Yes, the nurse had to unhook her from the IV. that was delivering morphine to her. And at the time, she didn't know this, but it turns out 0.19 milligrams per milliliter of morphine to the fetus, to her baby. And they unhook her from that so she can run down the hall to a public bathroom, not one of the private bathrooms in the emergency rooms, but this is in the hallway of the emergency department of the hospital. She has to run down to a public bathroom to go to the bathroom. That nurse at the time that unhooked her knew she was pregnant. And the emergency room doctor sitting at the nurse's station knew she was pregnant. And the nurses at the nursing station knew she was pregnant and watched her run down to the bathroom.
And she's in there for a while. It's not like she goes in and she's out in 2 minutes, right? How long does she stay inside that bathroom? Because we see her mother go down there. How long is she in there?
18 minutes.
So let's just recap here, because this is blowing my mind tonight, because I didn't realize that they actually knew. I thought the mistake they made was not reading the results, but what you're telling me is that they had actual knowledge that she was pregnant. They unhook her from the room. She goes to the bathroom saying that I have to go to the bathroom. I have to relieve myself in the bathroom. She's in there for 18 minutes and no one's concerned, no one's curious that maybe the pregnant person could be giving birth?
It's amazing, isn't it?
I didn't realize that, Gary. I was ready to cross-examine you tonight. I'll be honest. I was going to go after you like, okay, the results came in at 12:51, but nobody checked their email. But what you're telling me is that they knew and they assisted in allowing her to leave the hospital room and the care of a nurse and go down to this bathroom by herself for almost 20 minutes.
Yes, and that's been under oath. At the time, I wasn't aware because I didn't have all the records when we did the preliminary hearing in this matter. Discovery doesn't come that quickly into Mexico to defense attorneys, so I'm in the dark. But just out of curiosity and having some experience as a defense attorney, I cross-examined the nurse that unhooked her and said, "Did you know that she was pregnant? Did you see the test results at 12:51?" He admitted he had. I said, "Well, why didn't you tell her?"
Wow.
He said, "Well, I thought the emergency room doctor should be the one telling her." And so the doctor knew she was pregnant. The doctors admitted that. And the people at the nurse's station admitted that. It wasn't like they were busy. It wasn't like that they had to triage patients. They were sitting around and they flashed across their computers, just like lab reports are supposed to do. After the Affordable Care Act was passed, part of that bill was to force hospitals to have instantaneous delivery of this information. And that's part of the computerized systems we put in every hospital that gets some type of Medicare or Medicaid in the nation. So that's what happened here. They knew. But here's the other thing that everybody keeps forgetting. All this time they continue to give her morphine, knowing at 12:51, we have a pregnant woman and you continue to give her morphine? Excuse me, you gave her morphine for 48 more minutes after that. She and her baby. So no wonder we sued for malpractice.
Okay, so now let's talk about the lawsuit now. So this lawsuit is a civil suit. Most of the time when we are covering criminal trials, there's civil suits sometimes out there, and they're usually like frozen until the criminal case is over. Is this going to be a different situation? Are you going to proceed with the civil case and depose people and have that thing rolling at the same time that the criminal case is going? Or are you going to do criminal first, then the civil, or vice versa?
No, I'm going to proceed with both diligently. New Mexico has some pretty strict time limits to proceed, and we don't have much choice. We're going to do it. Besides, frankly, virtually all the medical records have been disclosed to the public. I don't have any medical records that haven't already been disclosed to the media and to the public. No disrespect meant to anybody from the media. I mean, that's your job. But they've disclosed all of this stuff against our wishes, but it's already out there. So I'm proceeding diligently in both, and I'm proceeding passionately in both.
And what will happen now when they want to depose her, your client?
Well, we haven't crossed that. We haven't crossed that river yet, but when we get to it, I'll make that decision. But by and large, we don't have much to hide in that regard. But that's still a decision to be made.
All right, Gary Mitchell. Always appreciate you coming on, and thank you so much. Again, I was ready. I was going to go after you tonight, Gary. I was like loading up, and I just but you know, the facts are what they are. Appreciate it.
They are.
All right.
Thank you kindly. Good to talk to you.
Good to talk to you. All right, let's bring in our think tank. Join us tonight in New York City, former senior homicide prosecutor Bernarda Villalona. Also with us in Cleveland, Ohio, criminal defense attorney Ian Friedman. And in Washington, D.C., the attorney who represented Johnny Depp in his defamation case, fellow at the American College of Trial Lawyers, Ben Chu. Great to see everyone tonight. Okay, I was going to go after him, Bernarda. You know I was going to go after him. Like, okay, yeah, the results came in, but nobody knew. And she went to no. So what do you think? What are your thoughts tonight, Bernarda, knowing about they're pointing the finger at the hospital. Obviously, prosecutors are pointing the finger at her. What happens here now?
Vinny, there's some huge issues here. Based on that interview from her attorney, her defense attorney, as well as her civil attorney, the question I have for the prosecutors is, what was the cause of death and what was the manner of death? Because if you can't prove the causation and you can't prove that the manner of death was homicide, then you can't charge her with homicide. You can't proceed with her in a criminal prosecution in regards to homicide if you can't link that the cause of death was related to her action here. Here, the defense attorney is saying that it was more of a negligence from the hospital point of view. And also what I wanted to point out, Vinny, is that he says something that morphine was administered to her after they knew that she was pregnant. So could the morphine have affected the child? Could that have been the cause of death? And if that's the case, then you can't charge her with homicide because it wasn't as a result of her action. But also remember, we're talking about also two different burdens. Remember, with the criminal prosecution, beyond a reasonable doubt, civil litigation, we're talking about preponderance of the evidence, and it could be under a different theory.
All right, Ian Friedman, have you ever seen a case, your long history as a criminal defense attorney, right? I'm not saying you're old. I mean, I'm older than you are.
Thank you.
I'm just saying you've done a lot of work. You've seen a lot of things. Have you ever seen a case where someone's accused of killing someone else and they file a civil suit against someone else, another entity?
Yeah.
You've seen that before?
Yes.
Like a
Absolutely.
Really?
Absolutely. Been involved. Yeah, been involved in it myself. And if Gary Mitchell's facts are correct, I consider him obviously the lawyer on the ground. He's taken an aggressive approach at it. Bringing that civil case is a wonderful mechanism, frankly, to get discovery, to get everybody deposed, so that the first time that you're in the courtroom is not at the criminal trial where life is on the line. I think obviously his goal, as it has been our goal, and other lawyers I know that have been in similar situations, is to reveal what actually occurred through the civil process. Here, assume that he's also obviously getting damages because they're due. But as a result of this case, of course, the prosecutors are going to be watching this. We'd much rather have the case unfold there in the civil courtroom than in the criminal realm where life is at line. So life is at stake, excuse me. So yes, in answer to your question, and yes, if his facts are correct, and I expect that Gary's are, it's an aggressive, but I like the move.
Yeah, I've never seen it in the cases we've covered on Court TV. It's always there's a wrongful death by the victim's family, right? Against the same person who's facing criminal charges. But here it's like, no, this person or this entity, the hospital is responsible, and the defendant, really the estate of the baby, is pointing the finger over there. All right, Ben Chu.
Vinny?
Yep.
Yeah, Vinny, the one thing I would say is sometimes, though, cases will be brought when you're being accused, maybe for a defamation or some other types of acts against the accusers. So there's lots of different ways to do it and lots of basis within the civil realm to bring it. So this is just one, but it does happen quite often, actually.
All right, Ben, how do you see this civil case unwinding? I mean, this is going to be problematic, I think, for the hospital to deal with, because we look at the body cams initially, and the people in the hospital are like, she killed this baby. This baby is dead. She put the baby in the trash. And now all of a sudden they're turning around and saying, wait a minute. The hospital does not have clean hands here.
Good to be with you, Vinny. I agree wholeheartedly with Ian. I think a good defense is a good offense, and I think this puts the hospital back on its heels and causes real problems for the prosecution. Also, what struck Bernarda struck me as well. I think the administration of morphine, which could have been the cause of death, I think really pokes a hole in the prosecution. So I think this is really problematic for both the hospital and the prosecution.
And I'll guarantee you they're going to have an expert that'll talk about that. Let me throw this at you, Bernard, and ask you if this changes the equation a little bit in the criminal case. Hypothetically, again, we don't have the evidence. She's presumed innocent. What if there is evidence that she knew she was pregnant? For example, maybe a classmate. She had told a classmate about it. And she kind of, knew she was pregnant, just didn't want to admit to her mother or anyone else that she had engaged in sex and didn't want to reveal that she was pregnant. Does that change the equation if when she ran down to that bathroom, she knew she was pregnant?
Still, Vinny, it still goes to the number one question. What was the cause of death and what was the manner of death? Obviously, the manner of death, they labeled it as a homicide. If not, she wouldn't have been charged on this homicide case. But my key question is, what caused the baby's death? Because even if she knew she was pregnant, again, it's not like she's a doctor or a nurse and said, oh, you can't give me morphine because according to my background, if you're pregnant, you're not supposed to have morphine.
But she was asked if she was pregnant.
She wouldn't have known.
She was asked if she was pregnant. She said no. As a matter of fact, she said she had never even had sex.
Yeah, but still,
which we know that's a lie.
No, but physics tell you that. But in terms of the morphine, though, would she have known that morphine being administered to her will cause her child's death? Again, we don't know. We don't know in terms of the autopsy what was the cause of death of that child. But there has to be a link. If you don't have that direct link of her actions causing the death of the child, it doesn't matter whether she knew or didn't know. Obviously, that's something to make the case stronger when we find out what that link is. But right now, it's still just a piece of the puzzle.
Okay, there's a lot of stuff. There's a lot of stuff. They did finish, yeah. There's a lot of stuff here. The more I'm looking at this, the more there's a lot more stuff about this one that I need to get into. Yeah. So I'm going to do probably a separate stream again to go more into this, because I don't think that. Well, I can't see. There's so much more. There's interviews and everything I can play. There's so much here that I need to splice it. Do you know what I mean? I need to get more. I need to get more document. Do you know what I mean? This is complicated. This is complicated, I think. But I'll do another stream, I think, dedicated just to this. I don't think this is a I don't think there is if there's a hearing, we don't know when it's going to be. So I can play the hearing tomorrow or something, so it's not a massive issue. Or I can play it whenever. So that's fine. Yeah, that's what I had, Murph, but I want to go through them. So there's about 7 or 8 videos of hospital staff interviews, which I'll play people. I'll play it. Don't have to go and look for it. I'll play it another time. And there's like CCTV footage and stuff. There's a ton. I just need to go and sort through it all, rather than just doing it live. Hello to you, Thankful. Good afternoon, all. Made it back from Dr. Okay, and another one tomorrow. I hope you went okay. Okay. So I'll look up all of them. I'll look up some documents. Maybe next week. We got plenty of time before the trial. We got plenty of time, people. So it'll be nice to do a refresher. I think we've had a snippet today. This is what I mean. That's what I mean. Whew. Right. what I'm going to do, so the plan today is I'm going to play the Judge Boyd. The verdict is in. So I'm going to play the defense witness. Basically, next 2.5 hours or so will be Judge Boyd trial for those that are caught up with it. Then after that, I am going to start a brand new trial. I'm starting a brand new trial today. In about 2.5 to 3 hours, I'm starting a brand new trial. I can't tell you what it is because it's two, and I want to see what it is. I don't think it's the Birchmore hearing, DNS. I think it's the one of the officers, wasn't it? Or am I wrong? That's what I was told. It wasn't about. It was to do with one or something like that. I don't know. I'm shutting my mouth because I'm not 100%. So I'll play Karen Reed. Fuck. Judge Boyd. Yeah, the officer. There you go. I'll play Judge Boyd now for the defense witness and that, and then I want to see if the trial starting in half an hour. If it's not starting, then I'm gonna do another trial. There's definitely another trial today I'm doing. So that's what I'm gonna do. Yeah, what I meant about Birchmore people was it's not directly as in because there's hearings coming up about the case of Birchmore. It's to do with the officers of Birchmore. That's what I meant. No, there's nothing to do with it. Right. Okay, so that's the plan. Right, so I'm gonna get Birchmore up here. Not Birchmore, fucking hell. I'm gonna get Boyd up here. When I can find her. So lots of you have been asking for the verdict. Oh, nah, I'll do that again. I'll do that one picture again. Okay. Close that one down. Close that one. Close. 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 Okay. Judge Boyd. So today's going to be a long day. Today will be a long day, people, for those that are interested. It's the next trial I'm doing is a murder trial. Just so you know, it's one or two, but it's a murder trial. I need to start in the right place here. Right. And I'm going to play it 1.25.
I deal with it. Deputy Mahia, do you have time to show her?
He asked for continuances based upon this.
For Mr. Jason Goss to be able to join.
All right, court is calling 2022 CR 11862, State of Texas versus Alexander Castro. Can I have parties announced for the record for the state?
Daniel Escobar and Jason Garaham for the state of Texas.
For the defense.
Jasmine Olguin, Your Honor, and I would like for Mr. Jason Goss to be able to join the trial. We're requesting that with the court. Mr. Hillier is not present as previously made aware of the court. He had to go out of the country.
All right, so he left to go on vacation. And so that the record can be clear, this was the date that parties chose. With regards to Mr. Goss sitting there, he hasn't been qualified for the jury. State, do you have any objections to him sitting?
Yes, Your Honor, the state objects to Mr. Goss sitting.
Your Honor, may I respond to that? I am his counsel of record. I have been entered as his counsel of record, and the state's right to not have me sit there does not supersede his constitutional right to have counsel and effective assistance of counsel, including counsel of his choice. Also,
are you not here in the beginning during jury selection if you are his counsel of record?
Your Honor, I, along with Jay Norton, Nicola Hood, Patrick Valentine, Jasmine Olkeen, and Gary Hillier are all his counsels of record who have entered a notice of
My
appearance.
question is, why were you not present during jury selection? This is the first time that you have been a part of this jury trial. So my question is, why were you not present during jury selection? Why have you not been present during the state's case in chief? Why are you just now making an appearance?
Yes, Your Honor. So I had other matters that I had to attend to. This was Mr. Hillier's case along with Ms. Olkeen. The state represented to the court that it would be a 3 or 4 day trial. Mr. Hillier repeatedly tried to tell the court that it would not. Mr. Hillier repeatedly asked for continuances based upon this vacation. Mr. Hillier put in a vacation letter and told the court that if it went longer than last week, then it would run into his vacation.
And a vacation letter does not a motion for continuance make. And this was the date that was chosen by the parties. This case had been reset before because counsel said he had a CLE to attend. So the court gave him time to attend his CLE, and this is the date that both parties chose.
And the court
he's in the middle of a trial. And then we go back to the question is, if you're going to be his attorney, why were you not here during any parts of this trial? This is the first time that you've appeared to sit. And if Mr. Hillier knew he was not going to be here, why did he not have you qualified before the jury? It would have been a simple matter of his asking the jury, we're going to have Jason Goss who may come sit with us. Does anybody know Jason Goss?
Mr. Hillier believed based upon when the court set this case, if the court remembers, the court set it for last Monday. The court decided not to go to trial last Monday.
Because he said that he had a CLE to attend where he was seeking to obtain his board certification.
No, Your Honor, the week before. That was the week before. Last Monday was when this trial started. The court told the parties that they would start on Monday and be here Monday. The court decided not to start until Tuesday. Had the court started on Monday, Mr. Hillier would have been here today. I mean, the case would have been over on Friday.
Mr. Hillier had a choice to make. He chose to go on his vacation.
Your Honor, the reason that there are vacation letters is because the courts have recognized that it is not a choice when somebody has a family, when they have non-refundable tickets, when they have plans that have been made for over a year's time. In addition to, he is not in a position where he could join them late because they are on a ship in the middle of the ocean. So he is not in a position that he could leave his family.
So you're telling me that cruises do not dock in different places?
They perhaps dock in different places, but he could not make it. He could not make half of the vacation with his family and was not willing to have his family go along without him. And that is why there are vacation letters. So the defense is asking for a continuance to allow Mr. Hillier back.
Oh, that's going to be denied.
I understand. And additionally,
and have you filed a motion for continuance?
Defense is asking for a continuance from the court at this time based upon these circumstances.
So you have not filed a motion for continuance, is that correct?
We will file a motion for continuance.
No, my question is, have you filed a motion for continuance?
The motion for continuance was filed before and it was denied.
Have you filed a motion for continuance? We're in the middle of a trial. Have you filed a motion for continuance now?
We have not. We will.
That will be denied.
Yes, Your Honor.
All right. So the issue is whether or not state, do you object to this counsel being present?
Yes, Your Honor, the state objects.
And based, as I argued before, they do not have the right to have a question about whether somebody on the jury might recognize me or look at me and know who I am. That right does not supersede my client's right to counsel of his choice and to effective representation of counsel.
Well, the counsel he chose was obviously Mr. Hillier because he was here. Ms. Olkeen was here. So those are the two counsels he chose from your firm. And again, we're back to the point. Why did you not appear for any stage of this trial before now?
Because the court and the state represented that the case would be done last week, and it was not. So based upon those representations made by the state 3 or 4 days, which is on video and on the record, in the court, who believed that it would be done last week, I had other settings that I had to go and appear at. And so
other settings that were jury trials?
Other settings that were potential jury trials that didn't turn out to be jury trials.
So not jury trials?
Not jury trials, Your Honor. However, in this situation, the state objecting in this situation to me sitting and assisting Ms. Olkeen is that right is so low on the totem pole compared to his right to allow me to sit here and assist Ms. Olkeen.
So hypothetically, let's say somebody from the state's office were to come down to sit there and they haven't been qualified before the jury.
Right.
And you say, oh, that's fine. And then we discover, oh, their mom is on the jury.
Right.
That would be fine with you.
Well, I know my mother's not on the jury.
No, that's I'm giving you a hypothetical.
The state does not have a constitutional right to counsel.
I'm giving you a hypothetical.
The state does not have a Sixth Amendment right to counsel.
So let me ask you this. So let's assume your mom is on this jury. Do you think that you should still be allowed to sit? Let's assume one of your best friends is on the jury. Do you think that would be a fair trial for the state for you to sit?
I think
yes or no?
I think that their issue with that would not outweigh his Sixth Amendment right. It's a constitutional right versus the state's disagreement or some possibility that does not exist.
Mm-hmm.
So no, my mother and my best friend are not on this jury.
Well, you wouldn't know that.
Well, so I would definitely know if my mother was.
Mm-hmm.
Right. So, and she's not, because I know where she is and she's not serving on this jury. As far as As far as the other balance, it's just a balance of rights. I mean, I am here. I'm willing to assist Ms. Holguin. It is important for my client's rights and the Sixth Amendment right to allow me to do that.
All right, are the jurors present? All right, let's line them up. One has raised their hand. State, do you have any questions with regards to that matter?
No, Your Honor.
All right, thank you. All right, with that being done, can I have attorney's approach?
Yeah, the court was on mute, people. The court was on mute, people. So don't worry. They were waiting for the jury to come in and to see if anyone knew the guy, and no one did. So she let him in. He's allowed to stay. So.
All right, defense, do you have any witnesses?
Your Honor, we do. We'd like to be heard outside the presence of the jury on a motion.
All right, so ladies and gentlemen, if you'll just step in the hallway for 2 minutes.
I'm not listening to emotion. Let's get straight into the meat and potatoes. So this is a defense case now. So just a reminder, once this is done, I'm going to create another stream just to start fresh on another trial.
Destiny Lechuga, Destiny, last name Lechuga, Lechuga.
Defense, you may proceed.
Yes, Your Honor. Good morning, Officer Lechuga.
Good morning.
So I'm sure the jury's wondering why you're not in your uniform. We've seen all the other officers in their uniform. Can you explain to them why that is?
Right now I'm on light duty, so I'm at the academy, not performing normal patrol functions. I'm just helping with TICO licensing and stuff like that. I'm can't perform my normal duties as a police officer right now.
Why can't you perform your normal duties?
Because I'm on FMLA leave, or I was on FMLA leave. I just had a baby, but now I'll be back on patrol in 2 weeks.
Congratulations on your baby. So once you've recovered, you'll be able to get back, like you said, on patrol in those 2 weeks.
Yes, ma'am.
And then you'll be able to be on your normal regular schedule.
Yes, ma'am.
Officer, we heard from Officer Morgan. He was one of the first officers on scene for the initial crash. What was your role on July 22nd, 2022 in regards to that first crash?
I was a cover officer, so I was just doing whatever Officer Morgan needed to secure the scene.
And as a cover officer, what was your role with the driver of that first accident, Shayna Lassell?
As his cover officer, I was just trying to eliminate traffic, but the two vehicles were blocking both lanes. So I was just trying to provide an open lane by pushing a vehicle out.
When you arrived, what did the scene look like with that first accident?
Traffic had been backed up all the way to the on-ramp of the exit ramp. So our vehicles were the last vehicles that were at the end of the traffic. We walked about, I don't even know how long. There was about 60 cars to this first accident. When we got there, one vehicle was facing the wrong way. The other vehicle was hit. It had passenger side damage. And the two drivers were out of the vehicle just saying they had been in a car accident.
What did that accident look like?
Just a major accident. Airbags had been deployed. And that's about it.
Was it a head-on collision?
Yes. Like I said, the damage of the first accident or the first vehicle had damage on the front, and the second vehicle had damage on the right passenger side.
And did you speak to both of those drivers from the first accident?
I can't remember if I spoke to the second driver, but I know I spoke to one driver.
And what was her name?
Sheila. I don't remember her last name.
Shayna Lassel?
Yes, ma'am. Shayna, I'm sorry.
And what did Miss Lassel tell you about the accident?
I'm gonna object to hearsay.
Sustained.
Your Honor, may I respond?
Yes.
Your Honor, we're not using it for the truth of the matter. May I approach?
No, I mean, you can respond.
Okay, we're not using it to prove the truth of the matter. What Shayna Lassel said is that she got an argument with her husband, and so she
All right,
heard on.
sorry. All right, the objection will be sustained.
Yes, Your Honor. Did what you spoke to Miss Lassel? The things that she told you, did it make sense to you as an officer?
Yes, she told me she had just been in
I'm
an
gonna object to hearsay.
Sustained. You're not allowed to say what anyone else told you. Do you understand?
Yes, ma'am.
All right.
She was explaining to you why she was driving on the wrong way of the road.
Yes, ma'am.
And from there, you continue your investigations.
Yes.
And you were the one that primarily was in charge of Miss Lassel throughout that night.
After Officer Morgan had responded to the second accident, yes.
Okay, I want to talk about kind of what you observed when you were watching Miss Lassel for that hour or so. Your Honor, may I create a demonstrative to reflect this witness's testimony?
State.
I'm gonna object, Judge. I don't know what demonstrative.
Well, let's see what the demonstrative is, and then the state, you can raise your objections at that time. The court is not aware of what demonstrative she's making.
Your Honor, I'm just going to write down her testimony about the description of Miss Lassel that night.
All right, then the state's objection will be sustained.
Okay, so let's talk about the signs of impairment that Miss Lassel showed that night. Was her speech slurred?
I'm gonna object to relevance.
Your Honor.
Ladies and gentlemen, if you'll step out in the hallway just briefly. All right, everyone, please be seated. All right, what's the relevance?
Your Honor, this goes directly to our defensive theory that Miss Shayna Lassel was a concurrent causation to this accident. This goes from the very beginning of our case of trying to establish that with the jury. And this officer is able to provide that light of the signs that Miss Lassel showed so that they can, it's already been testified, Judge, that the officers did not correctly control the traffic in this case. We're trying to establish what happened before that. And it goes to, did Mr. Castro actually cause the death? We believe that Miss Lassel was a concurrent cause to this.
State.
Judge, Ms. Lassel isn't on trial here. What she did or what observations the officer had about her aren't relevant to what Mr. Castro did. Again, the theory that they're trying to say is that it was a concurrent cause, but no one had died out on that road until Mr. Castro came along. So no one else caused the death of the victim except for Mr. Castro. So again, we're objecting to relevance.
Judge, may I briefly respond?
Yes, but just one moment. So with regards to relevance, the court is going to sustain the objection as it relates to whether or not this prior accident, whether or not that person was intoxicated or what the cause of it was. But as far as that there was an accident and that this, I'm sorry, what is her name?
Shayna Lassel.
You can question the officer about the fact that there was an accident, that Shayna Lassel was involved in this accident. And if it was a head-on collision or whatever the circumstances, that it was a head-on collision or however. All right. So this witness can testify to the fact that there was an accident involving this other person. She can testify to the fact if it was a head-on collision, but the court is sustaining the state's objection insofar as whether the other person was intoxicated or what the circumstances that caused the accident. But you are allowed to question this witness that there was an accident. It was involving this other person. And if it was a head-on collision, you are allowed to question her about that. But as far as the defense believing that this other person was intoxicated, the court is going to sustain the objection to relevance, the state's relevance as a part to that testimony.
So just so it's my understanding, we will not be able to get into our defensive theory of this case of concurrent causation.
How is the fact that you think, or this officer thinks, that the first accident was caused by someone who's intoxicated? How is the fact that the person was intoxicated, how is that interfering with your defense?
It goes to reckless behavior of Ms. Lassel and then the reckless behavior of the police, which set up this entire scene, which goes to the jury deciding if Mr. Castro was actually the cause of death or if these two other concurrent causations were the ones that actually caused it.
All right, so here's the court's ruling. And I want to be clear and hopefully everybody understands me. You are allowed to question this witness that there was an accident. And for purposes of the record, I'm just going to call it accident number one.
Yes, Judge.
You can ask her about accident number one. You can ask her, where were the cars positioned, however you want to ask that. However, the reason for the accident that you think accident number one was caused by somebody who was intoxicated, the court is sustaining the state's objection to relevance as to that portion. Do you understand?
Yes, Your Honor. May I make a bill of exception?
Sure.
Do you want me to do that right now?
You can either do it now or you can do it after you completed your questioning of the witness. Mr. Goss, we're not in mock trial. If you want to say something on the record, you're more than welcome to say something on the record.
Yes, Your Honor. I didn't want to. Yes, Your Honor. So we would like to ask her these questions. And just additionally, just so the record is clear, I understand the court's ruling. So the record is clear. The intoxication is reckless per se under the code. The fact that Ms. Lassel was intoxicated would make her criminally responsible for the things that happened afterwards. The way the court's ruling has, the court has limited us to here is that we cannot show that Ms. Lassel held criminal responsibility and was the criminal cause of the accident, which ended up in the death of the complainant in this case. And so we wanted to make that clear for the record. And then I guess if we can ask her the questions outside the presence of the jury, so they'll be preserved for the appellate court.
Yes. All right. So do you understand the court's ruling?
Yes, Judge.
All right, let's bring the jurors back in, please.
All right, for a jury.
Shayna Lassel, did you later find out that there was a second accident?
It was during the time I was handling the first accident that I heard the collision of a second accident.
And who did you believe was involved in that second accident initially?
Officer Morgan, because our vehicles were the last vehicles that had stopped traffic onto the on-ramp.
And when you finally made your way to Officer Morgan's car to check on him, did you then find out that a long line had formed after his vehicle?
I never saw anything past our vehicles. I never went back there.
And you believe that the second accident was caused because of the first
I'm
one?
going to object calls for a legal conclusion.
Sustained.
Based on your experience and observations that night, you believed that the accident was caused because of Shayna Lassel.
I'm going to object to a legal conclusion.
Sustained.
What was your belief about the second accident?
I'm again going to object to legal conclusion.
Sustained.
Would the second accident have occurred if traffic was not backed up because of Ms. Lassel's accident?
I'm going to object to legal conclusion.
Sustained.
Judge, this goes directly to her personal knowledge.
All right, sustained.
Officer Lechuga, later that night, you went and dropped off Shayna Lassel with her husband.
I'm going to object to relevance.
Overruled. You can answer.
I took her off the highway and took her to a parking lot where we met her husband, and she was given a ticket and released her husband.
No further questions, Your Honor. We pass the witness.
Another from the state.
All right, is this witness excused?
Yes, from the state judge.
Yes, Your Honor.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state of the defense. Do you understand?
Yes, ma'am.
All right, and if you'll remain in the back room.
Yes, ma'am.
All right, thank you. Defense, call your next witness.
Your Honor, may we approach?
Yes.
Well, I'm just going to get some dinner. I was so we back. They're on mute. Oh, fucking hell, court. Court's on mute.
Mr. Hillier was not in a position where he could not. The defendant is entitled to counsel of his choice, effective defense of counsel under the Sixth Amendment. As the court has seen, Mr. Hillier was very prepared in this case. He has been the first chair of this case, trying this case. And so we are asking that the cause be continued until Mr. Hillier can return in order to give the client the benefit of Mr. Hillier's ability to argue to a jury that he has formed a relationship with, that he has presented this case in front of. And denying that, we would say denies client 6-minute right to counsel of his choice, 6-minute right to effective counsel. And so we're asking for that continuance.
All right. So are you stating that Mr. Castro has not formed a relationship with you or all individuals in the firm?
Sorry, what, Judge?
So are you saying that Mr. Castro has not formed a relationship with you or all the members of the firm?
I am saying that Mr. Castro, I have met him, but Mr. Castro has understood from the beginning that Mr. Hillier, who has just come off of trying 2 different intoxication manslaughter trials, Mr. Hillier would be the primary attorney responsible for his case.
All right. And Ms. O'Gean has been here throughout the entirety of this trial?
Yes, Your Honor.
State?
Yes, Your Honor. Response to defense counsel's motion for continuance. One, defense counsel was made well aware of when this case was reset to because of the CLE. He agreed that this would be reset to that day when we started trial. So he was given an opportunity to object at that time. He did not object, brought up the fact that he was going on vacation, but felt.
Right. Just so everyone knows, the Alexi Traviso trial has been cancelled. So they just announced a major setback for the state's case against a New Mexico woman accused of murdering her newborn baby boy in a hospital bathroom has resulted in the cancellation of her trial date, at least for now. So there must have been a hearing then. It's privilege of medical. So in the end, 5th Judicial District Judge Jane Schuler-Gray, sitting in Carlsbad, agreed with the defense on the medical privilege issue. It was just wrong, Mitchell recently told Albuquerque-based ABC affiliate KOAT. I mean, all of us want to protect or should want to wish to protect our medical history. It's not something we want to broadcast to the rest of the state, and hers was broadcasted not just to the rest of the state, but the rest of the world. Hang on, see if there's anything else. Body-worn camera video on the January 27, 2023 incident quickly went viral, showing that one then. The hallway surveillance camera was leaked to the media. Second, Mitchell argued his client was effectively detained by the hospital on behalf of law enforcement. In fact, the doctor of the hospital waited until 2 police officers had arrived to ask Trevizo about what happened in the bathroom. This is the defense attorney claimed was a violation to the woman's Miranda rights under the 4th Amendment. The court agreed with that defense argument too. I think that without that evidence, they don't have a case because they're not entitled under the present decision of the trial court to utilize those medical records or to utilize any statement that she may have made, Mitchell added in comments to the press. In early July, District Attorney Diane Luce, who represents 3 counties, Eddy, Lee, and Shaves, asked the New Mexico Supreme Court to overturn the district court suppression remedy. The precise arguments advanced in the state's brief are unknown. A spokesperson for the district attorney's office told attorney's officer told Law and Crime the appeal is sealed by the court and cannot be shared in accordance with the state law generally limiting public records request. Still, the upshot is clear enough. A pretrial hearing slated for July 22nd did not occur. Trial was scheduled for the beginning of August 26th. That date, however, has now vanished from the district court dock entirely. Instead, there's a motion hearing slated for August 22nd at 1:30 p.m. While largely keeping mum, the prosecutors discussed their office's appeal. All I can say is that obviously it was evidence that we believe was proper, evidence that we believe that we should be allowed to use, and we respectfully disagree with the court. During last summer's hearing, the state did not contest the strength of the patient-doctor privilege, but rather said it did not apply. The defendant's mother is present in the room with her. Trevizo is also suing the hospital. The baby boy was born and died on January 27th. The New Mexico Supreme Court is under no time constraint to consider and rule on the appeal lodged by the state. So it's postponed. It's postponed, basically. Hey, Need Some Z's. Hello to you. Welcome, Need Some Z's. So it will still go ahead, but it's going to be capped. A lot of testimony is not going to be there. But the 22nd, there will be another hearing about the rest of the stuff, but it's postponed. It's not cancelled. Law and Crime did say cancelled, but it's not. Well, it is, but it's postponed. It still will happen. It still will happen, people. Right, let's get back to this. No, I don't know. I don't know that one. Sorry. Right, back to this one, and then
inclined to agree to the reset date of 1 week so he can attend the CLE. So he was well aware of the time constraints that he was under. So he did.
I'm skipping because I really don't care about that argument. They lost the argument. This is going to be closing statements now. They're just going through the jury instructions, which we don't need.
Alexander Castro was clearly insufficient, or if you have a reasonable doubt their use is capable when there is police to invest in signing his or her or not guilty and nothing else. After you
right
in this courtroom it is. And the reason being is if the state when her boyfriend came up here and testified.
Exit the court through the deputy.
Here we
Respectfully
go.
submitted, Judge Stephanie Boyd,
Closing statements.
187th District Court, Bexar County, Texas, and suitable forms are attached. State, are you prepared to proceed?
Yes, Your Honor.
All right, you may proceed.
State reserves this time to make program.
All right, defense?
Yes, Your Honor. This case is a tragedy. We told you from the very beginning that you would see things and you would hear things that would break your hearts. They've broken our hearts too. Miss Alexandra Sabert's death is a tragedy. There's no doubt about that. And throughout this trial, you have seen what the pain of that loss has meant. You saw it when her boyfriend came up here and testified. It was hard. We felt those emotions and we saw all of that. But the law requires you to set those emotions aside and to look at the evidence. The law that you took an oath to requires you to look at the evidence and see if the state has proven their case beyond a reasonable doubt. The judge read to you that you are instructed to not let bias, prejudice, or sympathy play any part in your deliberations, no matter how hard that is for us as humans. That is the law. In this courtroom it is. And the reason being is because the state has the burden today. They have the burden to prove beyond a reasonable doubt that Alex was reckless and that he recklessly caused the death of Miss Sabert. And they have not met that burden. Because what reckless means is that you are aware of those circumstances and you consciously disregard them. You know it's in front of you and you let it go. You keep driving. Keep going. You know that you keep driving, even though that means you're about to commit suicide or you're about to seriously injure yourself, like we heard the detective say. Those are the only two options. That's what the state wants you to believe, that Alex was aware. And the state hasn't proven that Alex was aware that there were actually cars stopped in the road. The evidence has not shown that. Now, the question is, should Alex have been aware? And all their evidence points to is that Alex should have been aware. He ought to have been aware that there were cars up ahead. But there has been no evidence to establish that he actually knew what was going on. Gary, I want to briefly mention him. Gary has been here throughout this trial. He's been with us, with Alex, and he unfortunately had to go out of the country. He wanted to be here, and he wanted to finish this case last week, as we hoped it would, but we could not finish last week. Now, even though Gary isn't here at one of the most important parts of Alex's trial, we ask you not to hold that against him, because I'm here, and I've been here with him and with you all throughout this trial. And I want to get into some of the things that Gary would have said if he were here. This case, when the state opened and talked about this case on Wednesday, they presented to you a case that just involved Alex crashing into Miss Sabert's car. They presented something that was straightforward and easy, that there were no issues at all. This case is not a case where he was driving wrong way on 281 and did a head-on collision. Because then, of course, he would have been aware of the cars coming in front of him. Of course. This case isn't where he's driving 91 miles per hour in a residential neighborhood and Miss Sabert's car is at a stop sign. Because then, of course, that's reckless. That's not what this case is. And I wouldn't be here before you guys today if that's what this case was about. This case is about the perfect storm. Whether we like it or not, that's what this case is about. The dominoes that Gary showed you from the beginning, the series of events that led up to this, the parts that all the different characters played for this to happen. But for Shayna Lassell driving the wrong way on 281, this accident wouldn't have occurred. But for her doing a head-on collision on 281 and causing cars to back up for miles, this accident wouldn't have occurred. And this isn't to throw the blame on someone else. We absolutely know that Alex is in some part responsible for this. This is not to distract you guys. This is not to confuse you guys. This is the facts. If Shayna Lassell didn't cause that accident, and if the officers would have done their job, then this wouldn't have happened. We know that Shayna Lassell, she was never charged for anything. We heard that she was given a ticket after she caused this and then taken to her husband. That's it. That's all we heard. She was going the wrong way on 281. She was, not Alex. And even though he was going 91 miles per hour, he was going the right way on a highway. We know that San Antonio Police Department arrived at 1:56 for the first accident. Second accident happened around 2:20 or so in the morning. That's 24 minutes. 24 minutes that we heard from Officer Morgan, who is an honest officer. He's a good guy. We know he was doing his best out there. We're not here to say he's completely to blame for this. Of course not. But should something have been done to warn people of this huge accident? Of course it should have. He himself told us that something should have been done to warn of the crash to approaching vehicles, because this provides notice to other drivers. There is a reason that the police department has a policy on what to do when accidents occur. It's because things like this have happened before. It's because they know that appropriate policies and procedures need to take place to warn drivers of what's going on, to avoid this from becoming anything larger. There were no flares at all. Now you'll see on the body cam in Coban, that's an evidence. Later on after the fact, after this accident has occurred, that they do implement flares and they close down the highway as they should have from the beginning. They did not reposition their vehicles. There was no reflective vest on, and there was no road closure. We do know that they had their lights on, but there was also a large buildup of traffic after those police vehicles. Cars and cars and cars, it went on. Going back to the crash report, which you have in front of you, and you will have it in evidence. We know that the responsibilities of the officer is to provide warning of the crash to approaching vehicles. They have to do that. They have to warn us. That is their job in the community. If there is a wrong way driver, if there is this sort of accident and it's at night and it's hard to see, you need to warn other drivers. They need to use flares. That's what their policy says. Call in fire units, request additional officers for traffic or crowd control. Officer Morgan was busy with the first accident. You see it on body cam. He's writing the report when this happens. But he could have requested other officers. And he said that to us. He could have. But he didn't. He did not do any of that. And what does that mean? That means that Alex was not aware of the accident that was in front of him. He was not. We also heard some statements from Officer Morgan. Now, when you see the body cam again, you'll see Alex get out of the car and he says he's okay. He's confused. He doesn't know what just happened. We've heard testimony. He was airborne. His truck flipped. He was in a serious collision. And that's not to victimize him, not at all. That's just to show the state that he was in when he got out of that truck. He did not know what happened. He was not aware of what he hit. He said he thought he hit an 18-wheeler. He never even knew about Miss Saber's car. Did not know about her. And we never heard from evidence at what point in time did he actually learn about her or her condition. All he knew was that there was an accident, it was serious, and he knew that he had to stay there. He cooperated the entire time. We didn't hear one piece of evidence that he didn't want to cooperate, that he didn't answer questions with the police. He did all of that. He did everything. He stayed for hours and hours and hours. He did not go to the hospital. He did not go to EMS. He stayed there, answered questions, cooperated. Because as you will hear, he said, I just want to know what happened. I want to know what happened. And later on, at some point, he does say that he believes that the Honda came under him, and he believes that the Honda was driving erratically. Now, we've heard testimony that there were cars going the wrong way. Now, Miss Saber, she didn't do anything wrong. We know that. She did not. She was just there. But what other cars were going the wrong way? We've heard from multiple witnesses that it was chaotic. We don't know what Alex saw right before that. We don't know if it was the wrong way drivers coming at him. We just don't know. He doesn't know because he suffered from that collision.
10 minutes in.
Speed limit. Now, the state has a burden to prove that Alex was reckless, and they have 7 different manners and means in front of you. The first being that speed limit. He was not going the prudent and reasonable speed limit that he should have. That alone is not enough. They have to prove that he knew what the speed limit was and that he recklessly disregarded it anyways. It's not just enough to say he was going 91 miles per hour. That's it, case closed. He shouldn't have done that. That's not the way the law works. They have to prove that he knew that it was a speed limit and he disregarded it anyways. What the evidence really shows us, what the photo that Miss Saber took that night, is that right along before the accident even took place, there is a work zone sign that says 45 miles per hour. We know that the accident took place before this. We know that the accident took place after this sign here. That's what the evidence in front of you will show. Right here. That's the only evidence at this table that the state, who has the burden, has provided you, that the accident right after it happened was 45 miles per hour. The issue with that is we have not heard any testimony of what the speed limit was before then. We don't know. Was it 60? Was it 70? Was it 65? Was it 75? No evidence. They want you to believe that he wasn't going the speed limit at 45 miles per hour. That was not the speed limit where the accident happened. And that's an unanswered question. That's an unanswered question that they haven't provided you. They've had multiple detectives testify, and none of them said half a mile before this accident, the speed limit was listed as this. 1 mile before the accident, the speed limit was listed as this. Nothing. Nothing at all. They just want you to look at that and say, okay, he's going double over the speed limit. That's it. That's not the case here. And if you have unanswered questions, if you go back to that deliberation room and you were wondering what was really the speed limit when the crash happened, where the crash happened, they owe you an answer to that. They owe you that answer. Proper lookout is another manner of means. Now, there was a visibility issue. We heard that from Joshua Rodriguez. Joshua Rodriguez was the one where he had his wife call 911. He was the only person that kind of saw the accident happen. He was the only person that was behind. And he says that he saw Alex speed up in front of him and heard the crash. He's an unbiased witness. He has no motive here. He's not coming from the government. What did he tell us? He said he could not even see what happened. Why? Because he could only see the roofs of the cars from his vantage point. That's all he could see. He could not see the police vehicle. He testified to that. And why is that? Well, he explained to us the highway, it curves, it goes up, and then it goes down. It's not straight and flat like the police want us to believe. Because this witness who was there that day behind the crash, he said that. He explained it to us. And if Joshua couldn't see what happened with the crash, then Alex couldn't see. He could not see that there was an accident in front of him. Leslie Salazar, she explained the chaos of the scene that night. She explained that there were cars that were reversing to try to get off the highway. They were impatient. They didn't want to stay there anymore. She called 911. And she told us she called 911 so they would know where to go because of the chaos of everything. Avoiding colliding with another vehicle, failing to brake, and proper following distance. Those are other manners and means. What we heard from Detective Doyle is that there was no evidence of braking. There was no evidence of swerving. There was no evidence of evasive action. What does that mean? What does that mean if somebody doesn't brake, swerve, take any sort of evasive action? when they're going towards an accident scene, when they're going towards standstill traffic. It means they're not aware. It means they're not aware unless they want to kill someone else and kill themselves. And there's been no evidence that he was actually aware of it. Detective Doyle says, well, if somebody doesn't brake, doesn't take evasive action, doesn't do all those things, it could be one reason is that they're not paying attention. And if they're not paying attention, then that means they're not aware. They're doing something else. We know that no one who is aware of that risk would do such a thing. No one. It doesn't make any sense. You have to use your common sense and know that there's no way that Alex could have been aware because he would have done something to prevent that. Now, the question is, should he have been aware? He should have been. Of course he should have. Paul Martinez, he told us he didn't see police. He just saw lights. He saw cars turning around going the opposite way. He saw cars going wrong way. There's about 5 or 7 of them that just kept going off of the highway, both sides. He's in his lane. He told us there's cars coming this way, one way, and there's cars coming this way as well. I saw it. That caused all of this. That all came together. And he himself told us he believed the accident was because of the wrong way drivers. He believed that, and he was there that night. Peter, he saw wrong way drivers as well. He saw Alex go in the air. And he also said something very important. Peter said there was a white car behind me. There was a white car behind me. Where is that white car? That means that there was a car in between Peter and Miss Saybert's vehicle. We don't know where that car is. We don't know if that's one of the cars that went the wrong way right before this accident happened. We just don't know. And that's a serious question. He said he probably turned around. This is not an intoxication manslaughter case. It's not. It wasn't charged as an intoxication manslaughter case. And we're asking you not to let the state make you believe or think that it's an intoxication manslaughter case, because there's been no evidence about that. There was so many officers on the scene, so many, and they could have brought you any one of them to say anything about this, and they didn't. None of the officers saw any signs. There was no signs of impairment. The only evidence that they have, and they have presented to you, was from Alex himself when he cooperated. And what Alex told the police is that I had 4 to 5 beers about 8 hours before this, around 6 p.m. when I was golfing. That's what he said. No witness testified to any signs. Their own experts said that he was not intoxicated. Officer Morgan, we asked him, he was the first officer, any signs of intoxication on Castro? No. There's 10 post-op clues. Did you notice anything? Slurred speech, wobbly, unsteady on feet? No, he did not. Detective Orta, their expert, he said Alex was not intoxicated. He's a specialist. He's trained to recognize certain clues. He performed the HGN on Alex. We know that. And he says that he saw 2 clues, but that wasn't enough, that he was not intoxicated. SAPD Detective Martinez. Detective Martinez, she told y'all that she smelled alcohol until Gary showed her video and reminded her that when she was there on scene that night, right then and there, she told her supervisor when he asked her, did you smell anything on Alex? She said no. Of course she wants to say yes after the fact. Of course she wants to hold somebody responsible for what happened. That's understandable. But that night, she said no, she did not smell anything. She knew that the primary crash was Shayna Lassell. She told us that Officer Morgan should have called them to let them know that there was a wrong way driver, but they didn't. We know that Alex consented to search his vehicle. He did that. After hours and hours and hours of being there, he told Detective Martinez asked him, can I search your vehicle? Can I get the airbags? Can I see how fast you were going? And he says yes. Even hours and hours of being held there, hours of being questioned, hours of knowing that he could not leave, that he was being detained, he still consented to that. This case is about an accident, a horrible accident. We heard that from the medical examiner who listed the manner of death in this case as an accident. Deadly weapon. Not true. It's not true that Alex intended to use his car as a deadly weapon. And we know that because he was not aware. This is not a case where somebody's just shooting in the middle of fireworks going on in the city where other people are around. Then of course you should be aware that there's people around you.
5
and
minutes.
Thank you, Judge. What comes up has to come down. You're aware of that. That's not this case here. He was not aware that this could happen. This is not a case where he was throwing a rock off the highway and he could have been aware that he would have killed somebody. He did not intend to use his vehicle to kill anybody because he was not even aware that somebody was there. When you go back there hold the state to their burden. Hold them to proving beyond a reasonable doubt that Alex knew of Miss Sabert's car in front of him and continued to go 91 anyways, continued knowing he would kill himself. And what that means beyond a reasonable doubt is that if you go back there and you think perhaps he knew, maybe he should have seen it, maybe that's not guilty. If you go back there and you think it's probably likely that he knew and he did it anyways, that's not guilty. The burden is beyond a reasonable doubt because they have to prove to you that he was actually aware of it and continued to do it anyways. Officer Lechuga, the state, when they presented this, they just wanted to go on to this accident. They did not mention anything new about the first one and the details of that. We had to bring the other officer this morning that you heard from today, Officer Lechuga, and we brought her to testify about Shayna Lassell. And she told us Shayna Lassell went the wrong way, caused his accident, and I wrote her a ticket and dropped her off with her husband. That's it. That's how this story ends. But for Shayna Lassell causing that horrific accident, Miss Sabert wouldn't have been standing in standstill traffic. She wouldn't have. She might have already been home. And but for the police not warning other drivers, not putting up flares, Alex would have been aware of what happened. He would have been aware that there was standstill traffic in front of him, but he wasn't. All their evidence points to is that he should have been aware. That's it. Not that he actually was, because it doesn't make sense for someone to do that. And we're asking that you find him not guilty of manslaughter because he was not aware of what happened. He could not have been aware that there was standstill traffic, and he would have not continued to drive at 91 miles per hour, knowing that there was a car in front of him. He would have not done that. We ask that you find him not guilty of manslaughter. And if you want to hold him criminally responsible for this, the only thing that the state has provided some evidence of is criminally negligent homicide. That's it. That he should have been aware. He should have been aware of what he was doing. But it's important to remember he was going 91 miles per hour on the highway at night when there's not usually a lot of cars. He wasn't going the wrong way. He wasn't in a residential area. It wasn't like that.
State.
We bear a heavy responsibility when we get behind the wheels of our cars. Each and every single one of us is aware of the fact that if we are irresponsible or if we are reckless or any of those things, that we can kill someone. That risk is inherent in driving a car. The defendant's actions were reckless that night. He knew exactly what the risk was of not hitting the brakes, of driving over 90 miles an hour, of not taking evasive action, of firing a missile into a crowd of people. You heard evidence from almost every single witness who was there at that scene. They all said that they saw this traffic. You heard from Leslie. She had more than enough time to see the traffic and to take an earlier exit to avoid it. The witnesses who were stuck in the traffic, they all clearly saw that there was a traffic buildup. The brake lights you could see for miles. Even the victim knew that there was traffic. All of them stopped. No one else died that night except for Alexander Seibert. No one else killed someone except for Alexander Castro. What was the very first thing he said when he got out of that car? I saw brake lights and I tried to brake. He knew what he was supposed to do in that situation, and he failed to do it. He never once changed his story, up at least the first 2 or 3 times he told this Officer Morgan, about saying, well, I didn't brake, or I didn't see it. Each and every single time was, I saw brake lights. We all agreed in Bordier, that's the universal sign of there's traffic, there's cars on the road. You need to slow down. But he didn't do it. And he tried to lie about it. There's no roadway evidence that he ever once touched those brakes. There's no roadway evidence that he ever once tried to turn the wheel. There is evidence that to the left of this traffic, there was a lane wide open for him to go into. And he could slow down at that point, but he decided not to. The defense has been arguing and saying, well, it would have to be suicidal in order for him to do something like that. Well, guess what happens when you do something that's so suicidal and you involve another person? Guess what? You're being reckless with the risk to that other person. The speed, 91 miles per hour, over 90, confirmed by both the black box data and the map, confirmed by what he did to those other cars.
You saw that in person yourself. That's what 91 miles per hour into the back of a car does to the other car. It destroys it. It obliterates it. That, of course, is a deadly weapon in the manner of its use. Driving a car 91 miles into the back of someone else is using a deadly weapon against that person. His actions were reckless. He never once took any of the responsibility that night. I tried to hit the brake. I gave it all I got. You guys can't blame me. But then he took that extra step. He knew that the victim was injured. He told Officer Morgan, they told me about how she's doing. Once he knew about that, he changed his story to now she came in to me. None of the evidence supports that. She was at almost a dead stop going to the right. He knew that she wasn't going to make it. And so there's that blip of someone else I could point the finger to and say it was them. At no point did he ever once say that there was that other cause other than her. He's blaming a little dead girl for his own actions. Because he knows what he was supposed to do. I hit the brakes and gave it all I got. Well, turns out he didn't. I tried to stop. I tried to avoid him. Didn't really do that either. Only one person that night killed someone else out on 281. Miss Alassel didn't put her foot on the pedal of that truck. SAPD wasn't behind the wheel, and she used to not evade. It's just him. Everyone would have been okay if not for his actions. The victim was still alive despite sitting in traffic. The accident had already happened and she was still alive. SAPD hadn't shut down that highway, and yet she was still alive. But it's when she crossed paths with him that she died. He's the cause of her death. Defense is bringing up criminally negligent homicide. That's what's called a lesser included offense. Less punishment.
Objection, Your Honor. That is improper argument.
Sustained.
Your Honor, we move for an instruction in disregard.
All right, ladies and gentlemen, you're just to disregard counsel's last statement.
Your Honor, we move for mistrial.
Denied.
Criminally negligent homicide that he should have known. He knew. He knew exactly what he was doing and what his actions would cause. Do not hesitate for a second there. Everything has been to blame everyone but himself. It's SAPD, Miss Alassel, it's Miss Siebert, but not him. SAPD messed up their investigation. There are several things that Officer Morgan stated that he could have done, and he didn't. That's a lucky break for the defendant. He got the benefit of that. There were no direct witnesses who immediately came forward and said, this is what I saw. It's another lucky break. That's another benefit. At this point in time, the lucky breaks need to stop. There needs to be accountability here. There needs to be someone, again, jury of his peers, who come in and say, enough is enough. To hold him accountable. To make sure that it is clear that this is not okay in our community. By saying not guilty or criminally negligent homicide, it's as if you're being asked to say, well, as long as SAPD doesn't set up flares, and as long as someone else causes that traffic buildup, slam into the back of someone going 90 miles per hour, that it's okay. Obviously, all of you know it's not. Because of the devastation it can cause to not just yourself, but the other people on that roadway. This was Alexander Siebert. She had just graduated from UTSA. Her life was only just about to start beginning. This is what the defendant did to her. This is what he caused by his actions. Doesn't even look like a car anymore. The conscious disregard, the safety of everyone else on that roadway. There's no evidence that he was sleepy. There's no evidence that he was distracted. There's no real evidence of anything other than the fact that his eyes were on that roadway. The state is asking you to find him guilty of manslaughter because that's what this is. It is the reckless disregard of the unjustifiable risk. The fact that someone would be willing to do this again. It's just shocking. State is asking that you find the defendant guilty of manslaughter. The state is asking that you find the deadly weapon allegation true. Because any vehicle going that fast, going into someone, deadly weapon, plain and simple. Anyone who says that they saw the brake lights and took no evasive action or no attempt to evade knew what they were doing. There's no highway in Texas that allows you to go up to 90 miles per hour.
Objection, Your Honor. Facts on and evidence.
Ladies and gentlemen, you'll remember that evidence as you received it.
Your Honor, may I get a ruling?
Yes, overruled. You'll remember the evidence as you received it.
The state is asking you to find him guilty of manslaughter.
Okay. There you go. There you go. Right, let's get to the verdict. Verdict. Let's get to the verdict. Verdict. Now. Oh, no, I didn't cover Wade Wilson. No, I did not. Right, we got another trial after this, people. So just remember, it's a murder trial. It's a murder trial. A murder trial. Here's the verdict, everybody. Here comes the verdict. The verdict is on its way. The verdict, we all here for the verdict. We all want the verdict now. It's quite a big case because look, we got this they're filming it and everything. If you see behind there, they're filming it. There's cameras in the court. So it's quite, hey, look at this attorney. Was he dancing on the way? Hey, John Travolta. Right. Well, sorry, Jessica. Oh my God, I was working and my stomach dropped when they said Alex, my sister's boyfriend, niece's dad was hit and killed. Oh no, in mass. They caught the guy today. He left him to die. Oh no. What, caught him today? Oh wow. Oh jeepers. I'm sorry to hear that, but I'm happy to hear that they caught him. Oh no, I know who he is, but I didn't cover it. Great timing, Rehab. I heard you singing the verdict. Got to be back. Hey, happy days. Well, we're doing it after this. I've set up another stream. We got a murder.
Yes.
All right, for the jury.
A murder trial. I'll get into it now. Here we go. Strap it in, ladies. Strap it in. I think everyone thinks guilty here.
All right, everyone, please be seated. All right, ladies and gentlemen, it's the court's understanding that you've reached a verdict in this case. Is that correct?
Yes.
And is that verdict unanimous?
Yes.
All right, if you'll hand the verdict form to Deputy Laura, please. All right, if defendant, please rise. All right, with regards to the charge of manslaughter, it says we find the defendant not guilty. With regards to the charge of criminally negligent homicide, says we find the defendant guilty. With regards to the use or exhibited use of a deadly weapon, it says we so find that a deadly weapon was used or exhibited, namely a motor vehicle. Does anyone wish to have the jurors polled?
No, Judge.
All right, ladies and gentlemen, I'm have you wait in the
Wow. Okay, hang on.
jury room, and then we'll call you back in a moment.
Well, the defense won, people.
All rise for jury.
Defense definitely won. That's what they're going for. That's what the defense were going for. I don't know how many years it is, though.
All right, everyone, please be seated. And state, do you have no problem. And are you ready to proceed with your witnesses?
Yes, judges, we just gotta have a moment to prepare that.
Yes.
We do have our witnesses present.
All right, so we'll have, is 11:15 enough time? Or do you need longer, or 11:30?
Yes, Judge, that'd be 11:30 be great, Judge.
All right, so we'll 11:30.
Your Honor, maybe just, I guess on the record, just so that I'm clear, well, can I discuss with the prosecutor, and then I might need to get on the record briefly.
For what purpose?
Well, we weren't given any notice of any 404 or 3707 notice in this case. And so I don't know who the witness is, and I don't know what evidence they're going to present, but we might object to it.
Well, you can object at that time.
Judge Boyd.
All right, is Sammy Salazar in custody?
Yes.
Okay.
Judge Boyd hates this guy.
Behave as.
Let's watch.
That's being recalled for tomorrow. This trial is complete. All right, so we'll bring you back tomorrow. You'll be brought dressed.
Sentencing.
All right.
So sentencing, Joe. I think he meant impact statements. Impact with the statements, I think. Oh, Christ. Crap. What did he get? Vehicular homicide. How many years is that? Yeah, I don't know how many years that is. Oh, days. So she's got, it said 11:30, but she's gone to lunch now. Have we missed something here?
Yes.
All right, for the jury.
All right, let's.
Yes. And is that verdict unanimous? All right, everyone, please be seated. Yes.
All right.
Verdict in this case, is that correct? Okay, Laura. Guilty, defendant guilty. With regards to the use or exhibited use of said, and the defendant not guilty. With regards to the charge of criminally negligent homicide, says we find the defendant guilty. With regards to the use or exhibited use of a deadly weapon, it says we so find that a deadly weapon was used or exhibited, namely a motor vehicle. Does anyone wish to have the jurors polled? No, Judge. All right, ladies and gentlemen, I'm have you wait in the jury room, and then we'll call you back in a moment.
Oh. Right, hang on. I'm trying to look for stuff here. Says something 3 years limitation. Um, I don't know. It says something about 3 years, but I don't actually know. Hang on. Victor criminal. Okay. No, I can't. I can't find it. So I think the jury sentence in I put I believe they sentence in Texas. And the judge just ratifies. So it says here somewhere. Where is it here? Hit a tree, right? Okay. So it says here that judges and juries are called for sentencing. So there you go. So I presume the jury will ask, will present something, and then it'll be up to the judge to ratify it. So I presume. I mean, in the document it says the jury or judge. Yeah, that was buffering. I paused it. I paused it, Daffodil. So it says the jury or judge or jury can sentence. So presume the jury is sentencing. Right, let's go back there for a second. So it'll be this afternoon, which obviously we don't have. They haven't done anything yet, so it's not there. So I'll give that a miss for that then. I do want to play one more thing before we leave. So right. Where's this gone? Just the two of us. We can reach if we try. Just the two of us. So this is the victim impact statements from the Chad Doberman. Carol found them. There's no pictures of the wife or daughter, but their audio can be heard here. So I think it is quite traumatic, as in quite emotional. So brace yourselves, or you might not want to watch it. Just in case you want to watch the murder trial I'm doing is Wisconsin murder trial. If you don't want to listen to this, then I'm probably going to go live in about 15 minutes over there. The link for that one is here if you just want to go over there straight away. But it's a trial. You can. I'm doing a murder trial straight after this, Elsie. I want to do it on a new stream because it'll keep it clean, rather than having to jump. Because today I've covered loads of different things, so that's why basically. So you should get redirected. If you don't, then that's the link. It's a triple murder homicide. It's a retrial on this guy. They couldn't come to the decision the first time out, and this is the second trial. It's all over like $600. Anyway, we'll explain that later. But here we go. This is the Doberman trial testimony. Thank you, Daffodil. Here we go, people. When I can find it. Nope. Here we go.
has taken place because the two victims, Ms. Laura Norman and Alexis, want to be here. And at this point in time, all cameras down, all any cell phones, any still photos, anything else in the off position. You're not to record either of these two women under any circumstances, and video, audio, and Ms. Barron Allen will read.
Not just a stepdad. I am the person who I am today because of you. And no matter what anyone says, you raised me well, and you gave me an amazing life, and I will forever be grateful for the memories and time you spent with me. Ever since what you've done, my life has been something I would never wish upon any family. It is the most heartbreaking and emotional thing anyone could go through. Chad, I miss you, and I miss the boys dearly, and nothing will ever be the same again because of you. Whenever something exciting happens, I always just want to tell you because I know you would be so proud of me. Softball to me isn't the same anymore because that was our sport, and that was the boys' sport. You made me an amazing ball player, and whenever I play softball, there isn't one game where I don't think about you. And whenever I get a good hit or I learn a new pitch, I always wish I could tell you because I know you would be so proud of me. And when good things like that happen, it sucks to look on the sideline and not see you be there, and for the boys not to be cheering me on like they always did. And Chad, I still work very hard on my grades, and I was on the honor roll this past year. And I know for a fact, if you were there to see it, you would be so happy for me because my grades have always been so important to me. Another thing that has impacted me was every single holiday. Waking up on Christmas isn't the same anymore. I don't get excited. I don't even look forward to having presents because it's not the same. I don't get to wake up early and wake the boys up. I don't get to hide the elf. I don't get to do any of the fun stuff anymore because they're gone and you took their lives. And Chad, when you go to bed every single night, I want you to know that when you took those 3 boys' lives away, you took mine and you took my mom's. Chad, I don't think you understand how hard it is to wake up every day and to see my friends and people around me have siblings and to hear them talk about what they did with their siblings that day or how much they enjoy having a brother. Because deep down, that hurts me so badly and so emotionally because it hurts to know I will never get to experience another day with my 3 brothers or to make any memories anymore because their innocent lives were taken away so quickly and horribly by their own father. Their father who they loved unconditionally and who they trusted more than anything. It is so painful to see you here and in jail for the rest of your life because I have never thought in a million years you would do this to your own children and family. And still to this day, it doesn't feel real to me that they are gone and I will never get them back. But Chad, if I'm being honest, I don't think I will ever be able to hate you. Even in 30 years from now, I will not hate you. Because yes, you did something so horrific and traumatic to those boys. But I will forever hold on to the memories I had with you and the boys because those are all happy memories. And those were the best times. And you gave me an amazing life and you were the best dad I could have ever asked for. I could write to you for days, but to end this off, always remember, I will never in a million years ever forgive you for what you have done and hope you pay for your actions like you deserve. But I will never hate you. On behalf of Laura Dorman, Your Honor. On June 15th, 2023, my life was changed forever. My life was ripped away from me and destroyed. Since that day, I have spent every day grieving the loss of my 3 sweet, so very little sons. I grieve the loss of Clayton, Hunter, and Chase every single day. And I grieve the life that they did not get to live. I no longer get to raise them and watch them grow. I miss each one of them so very much. I miss their laughter, silliness, love, and joy for life. Where there used to be so much laughter, happiness, noise of rowdy little boys, there is now silence and emptiness. I would do anything to push them on the swing, cover them up one more time, and hear their little ways of saying, I love you. All of it gone when I should have had so much more life left to live with them. I ask myself how a mother is supposed to carry on a life as a mom with 1 child left here on earth and 3 gone forever. I struggle every day with the will to get up or give up. Life for me is the true pain and suffering. I will never agree to think that any form of punishment could amount to the form of torture and suffering I have to endure each day. Such as seeing children and seeing siblings together as I watch Alexis be without her brothers, and seeing families together as I no longer have mine. Having to live a life where I'm visiting the same places I once was with Clayton, Hunter, and Chase all together. Traveling in the car and no longer seeing them in the rearview mirror. This also includes our family home that holds so many memories that I cannot let go of. But now it's just a devastating to face. Again, so empty and quiet. I was injured that day, fighting with every ounce of my body to just make it stop. I struggle every day, knowing I was not successful in doing so. And now I have to live with this and wonder what more I could have done to save them. This tragedy has affected me mentally and physically. I replay the events of that day over and over. I get sick at the thought. Every day I have to learn how to cope and live with the trauma I now have. I have anger, frustration, and so much sadness. I had plans and dreams to watch my small boys grow up and become young men, and to always be there for them as their mom, and to be the best grandma I could be. My husband I trusted with everything made a decision that has left my life forever changed. I lost my husband and my children to this horrible crime. The law will never replace my life and give me back what I have lost. I will hold the life I had and lived so close to my heart forever. Grief will never go away, as it is all the love that is left with no place to go. And my love for Clayton, Hunter, and Chase will never go away. And I will never let them be forgotten. I quote, "When I get to where I'm going, I'll only have happy tears. Until then, I will live my days with nothing but sadness." Thank you, Judge.
Thank you. Anything further on behalf of the state?
No, thank you.
Mr. Myers in mitigation? Mr. Haynes?
Yes.
Judge, just briefly, it's an agreed sentence jointly recommended. We just, with acknowledgement of the pain and the suffering, and the fact that these three beautiful boys are gone, Chad would never have done that, except that he was delusional, he was in psychosis when this happened. All three psychologists basically acknowledged that. Dr. Dreyer acknowledged it. They don't agree on whether it qualifies as long enough for serious mental illness or whether he had some appreciation of the legal wrongfulness of what he did. But the fact is, he loved those boys more than anything. And he was ill. He was sick, profoundly sick at the time. There's nothing more he can say at this point except that he's sorry about that. He did it. He acknowledges that. He's taking responsibility for it. He can't bring those boys back to do anything to do it. I think he would wish that he stayed at the little clinic for a little longer than he did. I think he wished that in hindsight he put signs there before this happened. Tried to power through it. He wouldn't do that again. And until it was too late, he couldn't. It was out of control.
Anything further on behalf?
No.
Mr. Dorman, is there anything you want to say on your own behalf before I impose sentence? No? Well, there's nothing that I can add to the most compelling statements of Alexis and Lord Norman. Those were two of the most compelling statements I've ever heard. With that said, Mr. Norman, as to count one, I'll impose a prison sentence of life in prison without the possibility of parole. No fine will be imposed. As to count two, it'll be a life prison term without the chance of parole. And count three, it'll be life in prison without the possibility of parole. These three counts and these three sentences will be served consecutively with one another. As to count 18, it'll be an 8-year minimum sentence. As to count 20, it'll be an 8-year minimum sentence. They will be served consecutively with one another for a total of 16 years as a minimum sentence. The maximum sentence would be 20 years. So the total sentence on those two are 16 to 20 years. They're served consecutively with the sentences in counts 1, 2, and 3. All aggravated circumstances have already been dismissed. Firearm specifications will be dismissed. You will forfeit the firearm that was used in this case. It will be forfeited to the sheriff's office for destruction, and it must be destroyed. There is no appeal for this sentence, so you will serve the rest of your life in prison. I will order judgment for court costs. You have been held in the county jail since June 15th, so there's 415 days that you've served in jail up to this point in time. That will be credited towards the life without parole. There's no restitution and no fines will be imposed. Anything further on behalf of the state, Mr. Colby?
No, Your Honor.
Mr. Myers, Mr. Haynes, anything further?
No,
No, thank you, Your Honor.
Covered everything satisfactorily?
I believe so.
Yes, sir.
Thank you. All right, thank you.
Thank you, Judge.
He'll be committed to the sheriff. Bond obviously will be revoked, subject, well, there was no bond anyway, but be committed to the county jail for conveyance to the state penal system.
Wow. I'm glad we heard it. I know it was an advocate that was reading it out, but it's quite impactful. The daughter, especially, I mean, I still don't hate you. Even after 30 years, I still won't hate you. It's like, yeah, he was in a mental health. He put himself in there, but he wasn't there for. I'm not sure how long he was there for. Not massively long. I don't know if he was on any kind of medication or anything. I don't think that's ever been released. There's no appeal. There's nothing. He's done for. That was part of it. There was no appeal. There was nothing. It's life sentence after life sentence after life sentence, plus I think 16 years twice as well at the top. So done. No, that's what I'm saying. It's impactful. Stormcat, it's good. It's good for her to just release. Do you know what I mean? It's good. Right. Note on that then. Right. As you know, I'm going to go to I'm beginning the other stream now. So if you do come over, this is the stream. You should automatically go over, but if you don't, that's it. Right, I'm going to close this stream down and start fresh on that one. So it's been a quite busy stream here, 5.5 hours. I'm just going to play a 20-second outro and then it'll hit you over there. If not, use the link. Right, people, catch you on the other side. And if I don't see you there, thank you for being here. As always, people, make sure you like and subscribe on the way out. And I'll see you in a little bit. Take care. Ta.
Thank you.